Stage-wise adjournment.
What happened to this? Pad illi. Provide one mouse pad here. ಸ್ವಲ್ಪ
Page-wise adjournment from admission matters. Page 3, 10 to 14. Page 4, 15 to 22.
My lords, serial number 15, my lords. I appear for the petitioner in this matter.
Serial number 15, yes.
My lords, the slight inconvenience today. The advocate on record is unwell. Also, he intends to file an statement of objection for the vacating IA, my lords.
Who?
Mr. Sandeep Lahari.
For petitioner.
Please, my lords.
File statement of objection for vacating.
Please, my lords.
It is a question of objection for vacating interim order.
My lords, he intends to file an.
He may intend to do so many things. Where is Mr. Rangaramu?
Rangaramu.
Have you informed Rangaramu?
My lords, I tried contacting them, my lords. I couldn't reach them. They didn't answer the calls, my lords.
All right. You inform him. If he's agreeable, then you can move at any time. In between also, you can mention.
Please,
This is a matrimonial matter, I think.
My lords, we have complied with the order. We have been paying maintenance. I've filed an affidavit to that effect, my lords. There's an high court order. I have been paying maintenance accordingly every month, my lords.
There's no arrears.
There's
No arrears.
No default, no arrears from my end, my lords.
All right. Now, please inform Mr. Rangaramu, advocate.
Please, my lords.
Learned counsel. What is your name?
Deepika Joshi.
Miss or Srimati?
Srimati. Deepika Joshi Lahari, my lords.
Joshi Lahari. You are having wakalat?
No, my lords.
On behalf of Shri Sandeep Lahari, advocate for the petitioner, seeks short accommodation. She informs that she submits that she will inform the learned counsel for respondent. Under such circumstances, release this matter next week. Next week, madam?
Grateful, my lords, grateful.
Yes.
Lordship, kindly me. Serial number 20. Connected matter, batch of matters, about 23 matters, WP number 9802 of 2022-21 and connected matters. My lord has posted to 17 to 2022 for hearing.
The same subject.
Same, sir.
It is posted on 17.
17.
So from 20 to 22.
20 only. I am appearing for 20.
All right.
2021.
So 20 and 20.2 we posted on 17.
17. An interim order expires today.
Learned counsel for the petitioner submits that a series of connected matters in WP 9802/2021 arising out of the same subject matter has been posted by this court, has been ordered to be listed by this court on 17. Accordingly, these two matters, 20 and 21, petition number, shall also be listed along with WP 9802 unconnected matters on 17.
Interim order expires today.
Interim order shall be continued till next date of hearing.
Fine. 23 and 24.
Find a memo. Filing. You are for? You are a sole respondent or how many respondents? Two respondents are there. What is your name? Learned Counsel Sri Abdul Qadir, representing respondents, submits respondent number 1 has died on 3/10/2020. And 23/10/2020. You file this in the. He submits that he is filing the memo to that effect in the registry today. Full stop. Relist this matter after 2 weeks. Have you informed Mr. Narasimhan? Inform him.
Matter for admission, where same authority RTA Bangalore, where in spite of direction of Dishonorable Court to dispose of my applications for temperament by RTA, respondent 1, the respondent to secretary sit out the judgment of Dishonorable Court and he passes an order. My lord already heard the matter and said it has to dispose of Thursday.
Are connected with the other?
The one matter.
Illa. When is that matter posted?
Because the same RTA Bangalore matter.
You said there already I have passed an order for disposal.
No, it was listed in office subjections. Matter was heard for some time, and I will inform my lord.
When do you want it?
17.
Why 17? Some auspicious day.
Where matters they have.
Hey, that's already we have so many matters on 17.
Friday.
Next week, what leave? Next week. Yes, madam.
Not for a transfer of the cases, the transfer the petition has been rejected. I filed CRP. All the matters, 12 matters.
You filed transfer and you want CRP.
My transfer petition is rejected. So I filed CRP.
Transfer petition rejected. CRP hakidira. Transfer of what?
Transfer of the cases.
All right. Next week. What for the wife? Salary from which Friday next week. No, next week. When it comes up after that, we'll see. So what do you want, sir? What matter is it? You're for whom? Who are you? Revision petitioner under tenant or landlord entry? Landlord, eviction ordered. But it will come in. From this side, yes.
Petitioner respondent. 6
Mr. Bairegowda, mute ಮಾಡಿ.
For the purchase of the high seas, this market fee has been.
We'll have it week after next. Next week. One is you are not visible. Second is you are not audible. You can pull the mic down, madam. Why are you acting like a school kid? You know you can move the mic wherever you want. Your submission should be audible to me to understand what you're saying. Yes.
The decision of claim was duly discussed by the trial court, my lordship, and the respondents even there are not in the case, my lordship, and to reject we have filed the rejection of claim and it was duly dismissed, so we have filed a CRP, my lordship. And
Week after next. Week after next. There is no urgency.
They're misusing the orders, my lordship.
What order?
The trial court order, my lordship.
Your application, your defendant?
And for the petitioner, my lordship. For the respondent, different by the trial court, my lordship.
Your application for rejection of plaint is rejected.
Yes, my lordship.
What is the stage in the suit now?
Now it is for evidence, my lordship. It issues not claimant, my lordship.
It will take 6 months. Week after next.
And for the petitioner, this was filed by the petitioner.
Huh?
In the Kola. And another petition was filed by the insurance company, the Bangalore. So it has to transfer the petition from Bangalore to Kola.
Transfer petition, you are saying. Put it. This also week after next. Sir, you are not audible. Mic hatra banni.
CRP number 240 of 2020. I am for the petitioners. This petition is filed challenging the order of the learned civil judge of rejecting application for rejection of plaint in the defense.
What is the stage in the suit?
Suit in the stage, it is at the stage of evidence.
Whose evidence? Plaintiff.
Plaintiff's evidence.
Week after next.
Petition seeking transfer of the petition to public court. The matter is already for the 2016 matter. Yes, and granted. How is the vacating stay?
Week after next. Who are you? Who are you? Your purchaser or your family member? Huh? For the stage in the suit now, different next week. Next week. No, sir.
This was not used.
Put it. Check it out.
This is pertaining to the transfer petition, transfer of matrimonial case from Bangalore rural to Bangalore urban. And this is petitioner is the wife. She has filed in Bangalore rural where she wants this to be transferred to Bangalore urban where the husband has already filed the petition. It's pending and nothing is happening. Both the matters are stalled. 2 years it is pending before the same court. So
Bangalore rural to Bangalore urban.
it is seeking the same care. Both the husband and wife have filed petitions.
You can go and move the principal court, isn't it? Right? No, you just satisfy this court. Take it, district. Next week.
Serial number 1, Aru Mahindra,
I'm for the petitioner, my lordship. My lordship, in this matter, hand summons was already served to respondent advocate in the trial court. So notice to the respondent may be dispensed, my lordship. And I have
And
filed memo along with the this one hand summons which has been signed by the respondent advocate in the trial court.
No, advocate is not sufficient, sir. You take out process fee to the respondent.
Please, Lord. Interim order may be extended, my lordship.
Interim order granted on 8/9/2021 is extended. Senate Council to comply to furnish the process fee for issuance of notice to respondent.
Much obliged.
Jagadish. Mr. Jagdish. A week's time is granted to do the needful. Chetan. Mr. Raj Prabhu. Week's time is granted to comply with the objections raised by the registry.
Appearing for the petitioner, my lord.
Yes.
Lordship, it will be complied, my lord. The process will be furnished today, my lord.
Lord Counsel submits that he will do the needful today. List next week. Sunil Narayan.
For petitioner, your lordship.
Yes.
On submission, your lordship, I have filed IA to modify the order passed by this honorable court. I had agreed by the order passed by the trial court, wherein court had ordered directed me to pay 34,000 with 2% interest. This honorable court was pleased to grant stay, but subject to payment of 34,000 in 4 weeks, your lordship.
Yes.
But my only humble submission, he's a poor small farmer. With great difficulty, he was running the family due to COVID. Last month, he could not get any work and could not muster the funds, your lordship. And further, my main contention is that under the Karnataka Debt Relief Act 2018, any debt incurred by the small farmer or poor laborer that should be discharged. My humble contention is that kindly modify the 34,000 ರೂಪಾಯಿ ಕಟ್ಟಲಿಕ್ಕೆ ಅವರಿಗೆ funds muster ಮಾಡಕ್ ಆಗಲಿಲ್ಲ ಸ್ವಾಮಿ 4 ವಾರದಲ್ಲಿ.
You have not paid any amount.
I have filed, that's why in para number 5, because I am a poor small farmer and due to COVID, ನನಗೆ ಯಾವುದೇ ವರ್ಕ್ ಬರಲಿಲ್ಲ ಸ್ವಾಮಿ, ಇನ್ಕಮ್ ಯಾವುದು ಜನರೇಟ್ ಆಗಲಿಲ್ಲ ನನಗೆ. ಅದರ ಜೊತೆಗೆ
sir, your order is not going to be modified. You take out notice to the respondent, you pay the PF. You take an order and you don't want to pay PF.
Kindly some time may be granted. I will
week's time is granted to the Senate Counsel for the petitioner to pay the process fee and for issuance of notice to respondent.
For the first respondent.
Yes.
The copy is not served, your lordship. The impleading application they have filed.
For the impleading applicant, a place week's time to comply, the officer to serve the copy of
week's time is granted to the impleading applicant to comply with the objections raised by the registrar. They'll furnish the copy of the same to the respective counsel on record. Await service of notice to respondent number 3. Interim order will stand extended till next date. Barasara non-compliance. Martira. Week's time granted at request of learned counsel for the writ petition.
Lord, I appear for the respondent husband in this case. I appear for the respondent husband.
The respondent writes a salary of 65,000. The trial court has passed an order 44,000.
You're for the wife. So you're agreed by the order of the family court. Family court or civil? Hasan. ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
4,000 ಕೊಟ್ಟಿದ್ದಾರೆ. 65,000 ಸಂಬಳ ಬರ್ತಾ ಇದೆ. 67,000 ಬರ್ತಾ ಇದೆ respondent.
He is drawing income of
67,000.
67,000.
They filed their
67,000. What is he working? Mr. Ravindra.
Please, my lord.
Have you filed objections to his IA1 for delay?
Lord, delay because I have already mentioned because almost 5 years there is a delay, my lord. So instead of filing,
are you having any objection or it can be allowed?
Not at because no, Lord, because if the application is allowed, my lord, then because it is only for enhancement which has been filed. Lord, she is alone residing in the Lord in the village.
Sir,
And,
don't go on merit. Simple question is,
sorry,
are you
Lord.
going
Not
to
yet filed.
file or you
Yeah,
have
yes,
any
definitely,
objection
Lord.
or no objection?
Definitely, I'll file. Lord. Definitely. I'll file.
You should take time and seek in stuff. They're going on the merits of the matter.
Sorry, Lord. Sorry.
Objection ಆಗ್ತಾರೆ.
2 years in the they have taken time.
Who has
No, I've already paid. I've already paid. In
For
another
what?
matter.
Objection to the IA.
We'll give him 1 week's time. If he doesn't file, we'll take it as not filed. Okay? You have satisfied why you are delayed by more than.
I filed due to inadvertence. I stated my affidavit.
More than 6 years, is it? Or 5 years?
There are 20 matters pending before the Honorable Court. Arrears of maintenance, the respondent did not pay regularly. We filed so many miscellaneous petitions under 128 TRBC, arrears of maintenance. And also the respondent filed the RPFC before this Honorable Court. The RPFC has stayed before this Honorable Court. Subsequently, they dismissed their matters. So many.
All right. Heard. Learned counsel for the petitioner, Shri N. Devendra. And learned counsel Sri Ravindranath.
Please,
for respondent. Learned counsel for the respondent seeks a week accommodation to file objections to the application IA number 1 of 2021.
Please.
Time is granted at his request. Finally, and if no objections are filed on the next date of hearing, matter will be heard.
I'll file it, Lord. Sorry, Lord, another connected matter is there in this matter. Already filed all arrears.
Second matter also is filed by you.
Arrears is already been filed. Arrears is already been filed. Entire arrears is already been filed.
Arrears is paid.
Entire file, Lord. Entire arrears is already deposited before the trial court.
At the time of the trial court has passed an order. Dismiss the our petition.
Second petition ಏನಕ್ಕೆ ಹಾಕಿದ್ರು?
Now maintenance package. Arrears of maintenance package.
ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ, ವೆರಿಫೈ ಮಾಡಿ.
I will deposit it in the trial court.
Just verify with your client. ಎಲ್ರಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
Before trial court, I have deposited.
Mr. Counsel, he submits that he has paid it before the trial court. Verify with your partner in the trial court. If it is not paid, they take the certified copy, file a memo, we'll pass further directions.
I will also file a memo along with that, whatever the receipt which has.
Also, please furnish a memo with whatever receipts.
Definitely.
Don't harass the wife. If you have given it, give the receipt.
No, Lord, definitely. See, I'm not.
Argue the matter, fight on merits.
Lord, I've already advised my client to deposit. He has deposited.
Yes. No date. Next week. Relist this matter next week.
Much of.
Syed Akbar Pasha, Papi Reddy.
Syed Akbar Pasha, Papi Reddy, please for respondent.
Syed Akbar Pasha. Syed Akbar Pasha. Papi Reddy, Mr. Papi Reddy. There is no representation on behalf of either side. Relist this matter next week. Yes, Mr. Gautam. Rejection of plaint. Rejected by
second respondent.
Who is this? Who's appearing for second respondent?
I represent second respondent, my lords, on behalf of Mr. A. Ravishankar.
On behalf of?
Mr. A. Ravishankar.
Ravishankar, that is R2. Are you the plaintiff?
No, my lords. I am the second defendant, city municipality.
And you have nothing much to say.
Please, my lords. Please.
Yes, sir.
We filed OS number 6.
You have to be audible, Mr. Gautam.
My lord, we filed suit in OS number 66 of 13 for a declaration that the plaintiff is absolute owner of suit scheduled property bearing number municipal site number 27 RBM Road, Hassan, which is 30 into 15 feet based on the sale date dated 9/10/2009. My lord. Then the different, this is
suit, which suit you filed? OS number?
OS number 66 of 13, my lord.
Ah.
Annexure G, page number 86 to 96, my lord. This was a declaration suit filed by me. Yeah, this suit is a shop, this is a small shop, my lord, which was allotted to me by the, this was allotment made in my favor. As per 9/10/2009 sale deed, my lord. On this.
What is the subject? Oh, the scheduled property?
Scheduled property is 13 to 15, my lord.
30 into 15. Shop.
It's a shop, my lord.
So shop is allotted to you by?
I should, my lord. Page number.
Shop is allotted by?
My lord, municipal, city municipal council.
All right.
As per sale deed dated 9/10/2009, my lord.
That is respondent number 2. Okay, you got it. All right.
Then the respondent also filed OS number 7. This was on 11/3/2019. I filed this suit.
Yes.
Then on 13/6/2016.
11/3/2000.
11/3/2013. I filed the suit.
All right.
Then he filed another suit on 13/6/2016.
What is that suit number?
That is our OS number 75 of 2016, which has resulted in this.
That is filed on?
That is on 13/6/2016. This is annexure B, page number 43 to 52.
All right.
He filed a suit to declare that he is entitled to get the allotment of suit premises in his favor.
Where is the plaint?
Page number 43, Manu. Wajid Khan, I'm Saroj Amman.
We come to the prayer.
Page number 50, my lord. Wherefore, for the foregoing reasons, plaintiff prays for a judgment and decree in his favor and against the defendant, thereby declaring that the plaintiff is entitled to get the allotment of suit premises by the city municipality Assam, and that the alleged registered sale deed dated 9/10/2009 executed by the city municipality Assam in favor of first defendant husband Veerraj in respect of suit premises is not binding and consequential relief of permanent injunction, thereby restraining the defendants, their men, and agents from interfering or otherwise causing any tortious act to the suit premises in possession of the plaintiff, and grant such other relief with court cost as the honorable court may deem fit to grant under the circumstances of the.
So you got the property on 9/10/2009 registered sale deed in your favor.
Based on this, I filed this suit, OS number 11/3/2013.
You filed original suits. What happened to that suit?
That was decreed in my favor. He filed RA, my lord. This decree is at page annexure N, page number.
What happened in the RA?
Then RA also decreed in my favor, my lord. His RA was dismissed. Decree was in my favor, my lord. Page number annexure N, page number 124 to 146, my lord.
So RA is dismissed.
Yes, my lord. RA is dismissed. Then he preferred RSA, my lord. RA is at page number as annexure.
RSA also dismissed.
RSA also dismissed. That is annexure Q, page number 176 of it.
All right. All right.
My lord, then he had also filed a counterclaim in the same
suit.
OS
60. What happened to his counterclaim?
It was rejected. He didn't prefer any appeal.
What was the counterclaim?
That this is not binding on him.
The sale deed.
Yes,
all right.
My lord, when then he should have gone in appeal. He has not gone in appeal. My lord, he filed a separate. Then this sale deed is not binding on him. But regarding this sale deed, the finding has clearly been expressed in the decree in OS number 66 of 13 that he has there is no allotment in his favor. That allotment of sale deed for me only.
That is in your suit.
My suit. All this were discussed in the decree.
Whether he has mentioned all this in his suit.
Yes, he challenged all the aspects in the earlier suit.
Yes.
My lord, page number 135.
Now your main ground is res judicata. Whether res judicata can be considered in order 7 to 11 for rejection of plaint. Huh? Can be considered.
Can be considered as my. Already, what has happened, the resident was already requested this.
Yes, yes, sir.
My lord, Honorable Justice, Honorable Justice Veerappa has, in a circumstance.
Sir, you need not take that name. You can tell what is the judgment.
Circumstance number 66 of 78, 2007.
What does it say?
There, the 7 to 11 was regarding rejection of claim. It was on the ground of res judicata, it was accepted.
And plaint rejected. What is this stage now in the suit?
Evidence.
Whose evidence?
There, other side. Now, what is happening?
What is?
The matter is dragging on for us, because we are and this litigation has been dragged on from 2013. If we even get an order that suit be disposed of as early.
What is the law on the point? What does the Honorable Apex Court say? This is on the point of Hindu Succession Act, sir. No cause of action. Where is the question of res judicata in this? Have you read this judgment fully?
Only point is, my conclusion is only that when the entire case has been disposed of, and all the things are discussed, even otherwise, even if it is not maintainable, I request this court, that the trial.
He is unrepresented. Have you taken out notice to the council on record?
My lord, already interim order was granted and there was an order.
Have you taken out notice to the party, that is the contesting party, who is the plaintiff, or to his counsel on before the trial court? La, Lena. Barkode. Heard Learned Counsel Sri Gautam Dev C. Ullal on behalf of the petitioner. The notice to respondent number 1, who is the plaintiff before the trial court, has been served, but he is unrepresented. Full stop. Learned counsel for the petitioner shall take out notice of this petition and serve a notice of this petition to the learned counsel appearing for the first respondent herein, who is the plaintiff before the trial court. He shall take out notice to before the trial. Take out notice to the council. Interim order shall stand extended. Find out. To my knowledge, res judicata will not. That's a matter of to be tried.
That's what is the finding given by the court also, I will find out. And
no, trial court may be wrong. I may be wrong. You have to follow Supreme Court. And if you are able to satisfy this court, you are right, you will get an order. Noting that judgment which you relied is order 7 rule 11A and D on cause of action and bar of limitation. It does not deal with res judicata. Ad kottbidi avargale, you can go through. Yes, next. Vijay Kumar.
Appearing for the petitioners.
Hmm.
But the petition Milord is the dependent number 6 petition. Milord,
They are co-defendants. Are they co-defendants?
Yeah, they were the defendants. Number 1 is the plaintiff, the other is the defendants.
Who are you? Yes.
Milord, regarding that point, Milord is concerned, we make a submission in the first date of hearing while matter come before the court for admission or the preliminary hearing stage. Their notice was dispensed to 2 to 6 is their placed expert in the trial court. My note in the first title of the petition also it is there. By taking into consideration, notice was ordered to only plaintiff. Since the plaintiff and defendant number 6.
Proceed next further.
Regarding merits of the case, Milord is concerned. Defendant number 6 is
What is this along with transfer certificate R1 filed by advocate?
On the date of the first elimination, there is second case. The plaintiff himself was not part. Because it is a small mistake in the last elimination. The age was mentioned as 33 years.
In your suit.
Yes.
Of age of the plaintiff.
Really taking advantage of that.
Page.
Yes, sir.
20.
Page number 20.
So 33 years anta heli. You said 33 years.
33 years.
Okay. What is your defense?
The defendant number 6 filed in a suit for partition filed by the plaintiff.
Your defendant number 6.
I am the defendant number 6 as a purchaser.
You purchased from whom?
Kindly turn to page number 24, Your Lordship. This is the plain prayer, Your Lordship. The schedule may and prayer kindly see that. Page number 24.
You purchased from whom?
I purchased the property from the defendant number 5. I am the 4th purchaser, Milord. The property is
so defendant number 5 is a family member or?
No, he is also a purchaser.
She
is also a purchaser. Shobha also a purchaser. My submission is point 7 to 11 D application filed before the trial court on 2 grounds. Number first ground, Milord, is that the suit is for the relief of partition and separate possession filed by the son, challenging the sale deed of 2011-1980 and further subsequent sale deeds. Milord, the scheduled property they have given before the trial court in page number 24 may kindly be
yes.
The total extent of property site number 10 Milord is measuring east to west 30 feet and north to south 40 feet. They filed a suit in respect of east to west 15 feet and north to south 40 feet. Since they clearly admitted that Milord only eastern portion of property they are seeking for partition. They are aware that Milord kindly see by looking into the rejection of plaint governments has to look into. It is a settled position of law. Kindly see the page number 22, para number 5 of the plaint. They admitted, Milord, kindly please, I may be permitted to read.
What is your inference on the prayer of 15 feet by 40 feet? The prayer is sought for
eastern portion of property only, the portion is 30-40. Half portion sold to my vendor, defendant number 5. Remaining portion has been also purchased by another purchaser. If they want to seek for partition and separate possession, they want to search for entire, they want to indeed entire whole property and seek a partition. But partial partition suit itself is not maintainable under the Hindu law. And moreover, they are not targeted, they are not only targeting this defendant who is there is a criminal dispute between the parties. Therefore, Milord, they are intending to file a partition suit against a son, challenging the sale deed of only half of the portion of property. Therefore, it is a settled position. Kindly see the page number, para number 22. I may be permitted to read.
Page 22.
Page number 22, para number 5 of the claim.
Yes.
The plaintiff submits that R. Krishnan has sold half of the scheduled property to R. Sundar Rajan, and another half portion, husband of the defendant number 7, Sundar Rajan, has sold his half portion of scheduled property to Lakshmama, mother of the defendant number 5.
Defendant 7
they are wrongly stated.
Which defendant are they meaning here?
That Sundar Rajan only, beloved. Husband of the defendant number 1, it has to take into consideration because they are wrongly shown. And after the death of Lakshmama, the 5th defendant has succeeded to the scheduled property, and thereafter Lakshmama sold the portion of scheduled property to the defendant number 6 herein under the register sale dated 22/9/2016. And the sale transaction that are entered in the so and so. Beloved, they admitted that only the Krishnan has sold the property half portion. Remaining half portion is concerned, they are admitted in para number 4. The plaintiff and 20 under the sale deed dated 20/11/1980, total property sold to Krishnan.
Yes.
Half of portion only thereafter, out of the half portion, Krishnan sold to Sundar Rajan, and Sundar Rajan to Lakshmama, Lakshmama to defendant number 5, defendant number 6 to the defendant number 7, subsequent purchaser. Therefore, Milord, remaining western portion of the property is concerned, they have not filed a suit for partition. In the schedule, kindly see, Milord, in the western boundary, they are admitted that western boundary is site number 10. So, when they are admitted and in the plain governments, only half of the portion, remaining portion is not there. Therefore, partial partition suit not maintainable. Therefore, on cause of action against this defendant from 1980 sale deed, first sale deed is, they filed a suit in Milord in the 2019.
Whether on that ground the plaint can be rejected?
Absolutely can be rejected.
Issue how?
Milord, I am relying on 3 judgments. One is
or go copy kotra nim.
Trial court will.
Where is the order of the trial court?
The trial court order, your lordship may kindly page number 13, it will started. The reasoning portion, Milord, will started on page number 15. There are 2 applications. The common order was passed by the trial court. One is 39 rule 1 and 2 application, another is 7 rule 11 the application.
Yes.
Milord, both we challenged in 39 1 and 2 is concerned. We challenged MFA stay granted the matter is pending consideration for this order. And regarding so far as 7 rule 11 is concerned, the reasoning part, Milord, kindly see that the reasoning, Milord, is para number 8. May I read, Milord?
Yes.
Page number 15. Answer to the.
You need not read the entire one.
The relevant, Milord, is concerned. Para number 10.
Para 13. Come to para 13.
And 13. In view of the observation made by our Honorable High Court in the decision referred by Supra by learned counsel for the plaintiff cannot be rejected if the plaintiff averments does not show suit is barred under any law. Further, it is equally settled while deciding an application under Order 7 Rule 11 of the CPC, court has to see the averments made in the plaint only, and contention taken in the written statement would be wholly irrelevant. So, if we go through the entire plaint averments, we can find that plaintiff has specifically pleaded to the effect the virtual propositors Siddaramaya died living behind the plaintiff's father Puttappa. Plaintiff and defendant 1 to 5 as legal heirs stating that said Puttappa was being allotted a bearing number 10, situated new municipal number 31 BBMP to extend 30/40 in the RT Nagar, post Bengaluru, and under the registered partition deed dated 8/3/1973. In this regard, if we go through the ornaments plaint, along with the contents of certified copy of the registered partition deed dated 8/3/1973, we can find that there was a partition between the original proposers Siddharamanna and his brother Timmaya on 4/10/1945. Further, the Schedule E property had fallen to the share of the plaintiff father S. Puttappa. In this regard, it is the case of the plaintiff, his father Puttappa adjudicated to bad voices and sold the scheduled property in favor of the third parties without knowledge or his consent. As such, same is not binding on these reasons, filed a suit for partition and separate possession.
will take me to the judgments which you are relying.
The first judgments, my lord, is concerned regarding to look into client governments is concerned, my lord, para number 4 of the client and para number 4 and 5 of the client, original client. It is clearly they are admitted by the plaintiff, stating that a property has been acquired, they are sold to the one Krishnan on 1980 sale deed. The remaining portion, my lord, they are further admitted that half of the portion to Sundar Rajan and Sundar Rajan subsequent sales, the defined number 6 is the latest purchaser in respect of eastern portion of the scheduled property. Remaining regarding western portion concerned, my lord, they have not disclosed before the court. In spite of disclosing a portion is sold, the cause of action they have shown in respect of only a portion of the property is concerned. Therefore, my lord, when the plaintiff approaches the court said, my lord, while deciding the question, while looking into whole client arguments, the plaint is plaint can be any suit is barred under any law, plaint can be rejected. Second judgment, my lord, is concerned.
How was this judgment helpful to you?
Cause of action does not arise for filing the suit against the only one purchaser. Second, my lord, is by client. This judgment will apply, my lord, is that by looking into the client governments while rejecting this is settled position of law, it is clearly admitted that the portion has been property has been sold. So they are within the knowledge of that as on date of filing of the suit, a property has been sold. So you cleverly drafted the plaint saying that only with regard to the eastern portion side you filed a suit for partition. Therefore, our drafting of plaint while filing the suit does not take away your entire because you intentionally have cause of action has shown against the only particular person. Therefore, 1980 deed was you are aware. The subsequent sale has been taken place also you are aware. You are pleaded in the plaint. Therefore, while reading of the plaint, your whole plaint itself is barred by law. Therefore, plaint can be rejected by exercising 7 Rule 11. The trial court. Regarding second judgment, my lord, is concerned. According to them, it is a father property acquired under the registered partition deed. They are admitted. That is the site number 10, measuring 30 into 40. My lord, the second judgment says, my lord, a property sold by a Karta once cannot dispute the power of Karta to sell the joint family property.
It's on the matter of merits.
My lord, next 1977 TV Satyapal and others versus my lord, where my lord, the relevant paragraph, my lord, last two paragraph in the said judgment, my lord, if a clever drafting has created the illusion of the cause of action, nip it in the bud of the first hearing by examining the parties searching under order 10 of the CPC. Well, this is a settled position in 1979, 1977 judgment TV is at the call judgment. But the Honorable Court of Export held the cause of action is they are cleverly drafted. They are not shown the remaining property. They are not. Therefore, the court can exercise power under 7 Rule 11. Complaint can be rejected.
Yes.
The second ground, my lord, is concerned. 33 years they filed. The plaintiff case was shown before the trial court is 33 years. My lord, 1980, the first sale was taken place. While filing of my lord, by taking into the age consideration, my lord, he was not at all born as on date of filing of as on date of property sold by a father in 1980. His age would be, my lord, is 1980 taken into consideration.
That is barred by limitation according to.
He was not at all born. Cause of action does not arise because before born itself, father sold the property. When his father sold the property in 1980, as on the day you are not at all born in. Therefore, the cause of action does not arise. Therefore, suit can be rejected even under 7 Rule 11A by exercising power. And that is one. Second, my lord, you cleverly drafted his.
Yes.
When the plaintiff has filed a suit, instituted a suit, they are aware that other purchaser. Therefore, my lord, you targeting only particular person. The cause of action is only a illusion of cause of action. Therefore,
who is the particular person? He is a brother. According to him, he says defendants who are his other brothers 1 to 4 have alienated to Krishna.
Not 1 to 4. Plaintiff and 1 to 4 are the brother and sisters. Father has sold the property in 1980. Father was, when the father sold 1980, first sale taken place to entire whole property to one artisan. He was not at all barred. If they have produced any document in the trial court or in the before this court only, they are coming.
So he was not at all born on that particular time. He said defense taken by you in the statement of your statement.
No, by reading of the plaint governments, by taking into plaint cast title, the age shown in the plaint Millard is 33 years in the year 2019. If we calculated Millard 2019 date of filing of the suit is 33 years, we calculated into 1980, he was not born. The sale when the father taken place. Therefore, the right to sue does not occur to the plaintiff to file a substitution of the suit for partition.
That is only by seeing the age on
by the last year's plaint governments.
Correct, sir. That is one part of your argument is by looking at the cost title 33 years. That is one. So thereby there is no cause of action is your argument.
One thing, absolutely.
Yes.
Second, Millard is concerned. In western portion, non-joint the partial partition is not maintainable. It is under 7 rule 11D and A. It can be exercised the power and suit can be rejected.
Yes. That's all.
Absolutely.
Yes.
Because the from the school of the date of birth is 2/1/1976. As I said, the statements completely last had an opportunity to correct it because of the 2020 proceedings itself has not happened. That is why I could not amend the end. But even then I had an opportunity when the matter was for trial. When I had an opportunity to produce the document before the court, on the date of the first alienation, and I was born. Number 2,
where have you said in the plaint? Where have you said in your plaint pleadings?
Date of birth I have not produced.
Date of birth already. I was alive. I was not given a share. I was entitled for a share.
Start from paragraph 4. Plaintiff submits the father of the plaintiff was living in royal life and was not taking care of the family. The father of the plaintiff was also gambling regularly. In order to meet his royal duties, the father of the plaintiff, without the knowledge and consent of the plaintiff, of the defendant want to fall, sold the social property to Krishna under registered sale details from Saul. But the property was acquired by my father, the father of the plaintiff, under a registered partition deed that was entered into between he and his mother. But why respect sufficient before the court law was heard that he, without the knowledge and consent of the anyone of the family members, he has sold the property. But that does not give me a clear right to question the action of the father.
What is the stage in the suit now? What is the stage in the suit?
Evidence. Because of this old evidence is not.
All right. So we'll admit and hear you. We'll admit the matter and hear you in detail. Satisfy. How? Merely by asking for quoting number age as 33 in the cost title.
Second ground is concerned is a legal ground. Millard is a 1980 LDD challenge in 2019.
That is the limitation.
Date of knowledge.
That is the ground of limitation.
Limitation is a mixed question of law. In fact, it is a settled proposition of law. Regarding you challenging only a motion is concerned.
It's a matter of trial whether on that ground plaint can be rejected.
Partial partition, frame of IC by looking into the
partial partition, you have to go through the trial, sir.
Not trial.
Where does it say it can? The plaint can be rejected merely by asking for partial partition. Let the court frame issues. Let the court frame preliminary issue. On that you lead evidence and you convince the court, and the court may pass an order in your favor.
Whether the plaintiff has make out a cause of action to file a suit targeting only the defendant number 6. Non-disclosing
cause of action is bundle of facts.
That's why the TV Satyapal judgment says that by reading a plaintiff, we look into the.
Correct, sir. We are not ruling out. You satisfy. I am prima facie not satisfied with your argument. Please satisfy this court. We hear you.
My submission before the court, they are.
Whether stay is granted in this.
Notice and order to come, let them say, then we will consider your submission to the court.
So no order is passed on your application for stay.
Notice was ordered, trial court date we told before the trial earlier. Before that we will take a notice and we will give a chance.
All right, now that notice is ordered, he's appeared also. You are Suresh Babu? Or one. All right, work on him. What is the stage in the suit now?
Evidence, we have to commence.
Plaintiff.
Plaintiff evidence have to commence.
Each time I file objection to the stay applications.
You have not filed till now. What were you doing?
Earlier also they took time, my lord.
Yavati, the trial court. When is the matter in the trial court? Trial court Yavati, sir. Next month. All right. We'll grant him a week's time, Mr. Counsel. Let him file his objections. What is the next date of hearing before the trial?
I will next date. I don't know whether I will search.
It is in the next month. We'll have this matter after 2 weeks in this month
Date
only.
may kindly fix up this.
We'll have it within this 2 weeks in this month only. Meanwhile, you find out if there is anything coming up before that, don't precipitate the matter in the trial court. Heard learned counsel for the petitioner and learned counsel for the respondent number 1. Any order is passed by this court dispensing notice to respondents 2 to 6?
Then we make a note and submit it.
Whether any order is, no, they were placed ex parte.
Yes, sir.
Respondent number 1 is none other than the plaintiff before the trial court. He is being served and represented by learned counsel Sri B. N. Suresh Babu, who is present before the court today. The other respondents, namely respondents 2 to 6, are the defendants number 1 to 5 before the court, before the trial court. Stop. Senate counsel for the petitioner has made a note that notice to respondents number 2 to 6 herein, who are the defendants number 1 to 5 before the trial court, may be dispensed with in view of the fact that they were placed ex parte before the trial court. Accordingly, in view of the fact that the defendants number 1 to 5, who are respondents number 2 to 6 herein, were placed ex parte before the trial court, and they are none other than the co-defendants. Since no relief is sought against them, the notice to respondents number 2 to 6 is dispensed with at the risk of the petitioner. Relist this matter after 2 weeks. They will not do. Come back. Don't precipitate the matter. They are put.
My lord, in this case, I am for the petitioner. It is the defendant number 2 revision petition.
Yes.
My lord, the plaintiff, my lord, respondent number 1 before this revision.
So Adiga, you are appearing for? Huh? No, we'll see. Yeah, already. Yes, sir. Mr. Arvind.
Yes, ma'am. My lord, it is, my lord, defendant number 2, revision petitioner, my lord.
Yes.
The petitioner is the, my lord, police sub-inspector, my lord, presently is working in Kundapur Taluk. During his official capacity, my lord, the respondent number 2, who is the defendant number 1 before the trial court, one Mr. Harsha, executive officer, has filed a complaint before the police station, my lord, as per annexer. Page number 61, my lord. My lord, got it, my lord?
Yes.
Page number 61, my lord. 63 is the typed copy, my lord. Can I read the typed or manuscript? Can I read page number 61, my lord?
Respondent number 2.
Yes, my lord.
So he is the first defendant.
Yes, my lord. Yes. Harsha KB, my lord.
First defendant filed a complaint before the second defendant.
Yes, my lord.
All right. Against you.
Against the plaintiff, my lord. Plaintiff.
Yes.
I permitted to read my lord complaint.
So no need, sir. You come to
yes.
the and for rejection of plaint. I don't want to
yes,
know.
my lord. Yes. This is the complaint, my lord, filed by the defendant number 1 before the defendant number 2, my lord. As per this, my lord, the FIR is registered by the defendant number present petitioner, my lord. The same is challenged by the plaintiff, my lord, before this Honorable Court as per annexer, page number 66, my lord, annexer E. 66, my lord, annexer E. In WP number 18017 of 2019. Before this proceedings, my lord, the defendant number 2 or 1 not made at party, my lord. Though, my lord, it is FIR is the said petition is allowed. The proceedings pending against the petitioner in FIR number registered by Karakala Police Station, Karakala Udupi District, so and so, punishment under section 353 and 171 IPC, so and so, the respondent police act.
See, the proceedings initiated against the plaintiff came to be quashed.
Quashed, my lord, and the concerned authority would at liberty to issue challenge or cause to issue the notice to the petitioner for removal of obstruction of, if any, which being the effects or fixed on the end screen of the vehicle in question, if it is causes obstruction. This is the facts of the case, my lord. Now, my lord, after getting this order, my lord, the present suit came to be filed by the plaintiff respondent number 1, my lord.
For what?
For claiming damages and defamation.
All right.
For seeking 5 lakhs rupees, my lord, against the defendant.
Yes.
Hence, my lord, I have appear before the trial court and filed my rejection of claims. During my official capacity, I am doing my job. Hence, the proceedings against me is not maintainable. Hence, kindly reject the plight. In support of my contention, I have taken 2 grounds, my lord. The said suit mode is not taken prior permission under the KP Act or not taken under the 197 of the CRPC. However, before the trial court note, the plea of the present petitioner is admitted, but the finding of the trial court note for a take note for a moment. Page number 48. Paragraph 46, page number 48. As there is a question of good faith and bad faith is involved, so also involved in question whether act done by the defendant number 2 was in official capacity in discharge of his official capacity. This court is the opinion that material question of sanction raised by defendant number 2 cannot be decided this pre-trial stage. Though, my lord, I made out the prima facie case, my lord, I being a police officer, my lord, I discharged my official duty. Though is a complaint filed by the is an election officer.
Which court has sanctified your act that it is on official duty?
Yes, during my official duty, my lord, as per the complaint, I registered the FIR.
So you are registered. There is a FIR registered.
Yes,
Yes.
that is the case, my lord. He filed the petition before this court, my lord.
That is quashed.
Yes, my lord.
That is quashed by this court.
Yes, based
Now
on
it is a
that
claim of the plaintiff.
Yes.
That you have not done it on official duty. You have come and you have bulldozed into his office and you have told him to remove. So that's a matter which is yet not yet decided.
Complaint filed by the defined number 1, my lord. For a moment, kindly take note. That is the reason I permitted to read, my lord.
Complaint filed by?
Defined number 1, my lord.
You need not read that, Mr. Counsel. You show by the plaint how it is barred.
Though, my lord, he has not taken prior permission from the authority, my lord, under the act.
That is if you are doing it on official duty.
Yes, my lord, I am discharging my official duty, my lord, based on the complaint, my lord, filed by the election
Which
officer.
court has declared that you are doing it on official duty?
Well, it is obvious, my lord, it shows that I am working as
Obvious.
police
How it
inspector.
is obvious? You just barge in by wearing your police uniform into an advocate's office.
No, my lord, I am not going, my lord. After filing complaint, my lord, I registered the FIR.
All right, that's a matter of trial now.
The election officer is going, election officer is going before the, my lord, lawyer office, my lord.
You show it by the plaint government how it is barred, sir.
My lord,
You are appearing for plaintiff? Yes.
The sanction, my lord, is very much necessary, my lord, under the act.
That's a matter of trial, sir. Whether if you have shown and you are able to prove that you are doing it officially, then that the court may consider whether the suit is maintainable or not. Not at the case stage of rejection of plaint. Go and face the trial. Any stay is granted?
No, my lord, it is the first time it is admission, my lord.
Okay.
Listed.
All right. Yes, Mr. Adiga.
Application for rejection of claim can kindly be seen. That also it does not disclose order 11, order 7, rule 11. You kindly see page 82, page 80. Page 82, annexure G. For the reasons stated in the accompanying memo of facts, may be pleased to take the plaint as the plaintiff does not disclose proper cause of action. What is that proper cause of action? Nowhere it is stated. And my lord, there is the Supreme Court has said it is not merely saying there is no cause of action. Proper cause of action does not come under Order 7, Rule 11. The trial court has gone into that aspect. Another aspect of the matter is this section 170. The sanction is not obtained. My lord, the application is filed, that is placed before the court along with the plaint. My lord, there is a deemed sanction. And my lord, this particular officer writes to his superiors requesting the superiors to provide him with the assistance of a lawyer. That is refused. They say that we cannot, for this kind of acts, we cannot lend you assistance of government.
All right.
And the section 80 notice, section 80 notice is given, exhibit P6. I have placed before the court the exhibit P6.
No, evidence has come in. This is on preliminary issues.
No. What happened? They did not file the written statement. They did not appear. He was placed ex parte. Then ex parte order was recalled. The written statement was not filed. Now he filed the written statement. That is also taken on record.
So there was an ex parte judgment and decree.
No. He was just placed ex parte.
Now, how did you lead evidence?
No, the others were there who had put in appearance, for whom the advocate is appearing.
No, sir. Whether the matter is proceeded on evidence.
It was proceeded on evidence.
After that, he filed this
After
application.
that, he filed the application.
After your evidence and marking of documents.
Marking of documents.
That is why Exhibit P7 is
Yes,
you're relying.
Yes, yes. Then my court said, all that we will give him the chance of filing the return statement. Now return statement is filed. Matter is going on. And kindly see annexure 8 at page 48. The notice was given. Section 80 notice is not given is what.
Yes, Mr. Arvind, you want to say?
No, my lord, note my senior counsel is just submitted. More evidence is not going on. Not it is evidence is adjourned by 28/2, my lord.
Mr. Counsel.
Yes, ma'am.
The question posed by the court was whether evidence was already recorded because they're relying the trial court while passing the impugned order has relied on Exhibit P7.
It is, my lord, initially, my lord, expertise order it was recalled and I filed rejection of claim. Subsequently, my lord, I filed return statement also. Now the posted for 28/2 for evidence of PW1, my lord.
Correct. Correct. Where is your plaint?
It is at page 74.
74.
Yeah.
Whether you have stated so in your plaint?
Yes, all that and produce the documents also.
No, with regard to your the intimation for seeking permission to prosecute sanction. We mentioned that in your plaint.
Our deemed sanction ಅಂತ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ ಗವರ್ನರಿಗೆ ಲೆಟರ್ ಕೊಟ್ವಿ ಅವ್ರು ಕೊಡ್ಲಿಲ್ಲ ಹಂಗಾಗಿ ಫೈಲ್ ಮಾಡ್ಬಿಟ್ವಿ ಅಂತ ಹೇಳ್ತಾರೆ.
Whether that is mentioned in the plaint.
Kindly see the list of documents. It is attached. Serial number 7 at page 79. Page 79. Office copy of the notice sent to the second defendant under section 170 of the TP Act. Earlier to it is office copy of the notice sent to the defendants 1 and 3. That is under section 80. All that is said.
Yes, yes.
Page number 85, not the objection filed by the plaintiff to the IA number 3. 85, not paragraph 4. The plaintiff has sought for sanction, His Excellency, the Governor of Karnataka, to prosecute the second defendant applicant, Exhibit P7. The copy of the same is acknowledged, produced as the ninth document in the plaint. It is respectfully submitted that sanction is deemed have been accorded by the competent authority.
Yes, yes, sought for sanction to prosecute.
His application is not sanction, but it is pending consideration. He's taken a ground, it is deemed.
Read the next para. Read the next para.
Accorded by the competent authority, if there is no response to the application for the sanction within 4 months, as per the ruling reported in 2013-83 SEC 2000. By relying on this judgment plot, he has filed the suit stating that it is a deemed sanction.
Yes.
Though, admittedly, my lord, I being the police officer, as per the informed complaint filed by the defendant number 1, I registered the FIR, my lord. Both the parties not made personally; they are not made party before the writ proceedings. Mere not quashing up the my lord FIR. He can claim my lord for damages against the police officers.
Yes.
My lord may also kindly see annexure 7. However, this man was threatening to detain the petitioner.
Sir, all that is a matter of trial.
Yes. I'm only bringing to the facts which are glaring at her.
Yes, we'll dispose it of, sir, with your consent, both of you. Will dispose.
Yes, my lord, you kindly take out of my submission. That's all.
All right. Recording.
No, if my lord, notice is required, my lord, for respondent number, defendant number 2. He is also necessary party, my lord.
Yaro.
Election officer.
This was during the election period, is it?
Yes, my dear. Cause of
No
action.
notice is ordered?
Yes, my dear, admission notice agla. First time ಬಂದಿದೆ. Initially, my lord, I filed the writ petition, my
Appearing
lord.
for the first respondent. Caveat.
Yes, my dear. Caveat to plaintiff.
Appearing for the plaintiff.
Other respondents notice ಆಗಿಲ್ಲ.
Other notice.
ಇಲ್ಲ ಯಾರಿಗೆ ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ. First time ಬರ್ತಾ ಇರೋದು.
Initially, ನಾನು writ
It is
ಹಾಕಿದ್ದೆ.
only on my application, the order came, the application which came to be rejected was IA number 3, against which the petitioner has grievance. In that, I was the only contesting respondent, IA number 3.
For the state.
Now it is again, my lord.
28-2, my lord. Posted for 28-2.
Lord Counsel Sri Arvind H for the petitioner, who is the defendant number 2 before the trial court. Lord Counsel Sri Chandrakant Adiga K. Represents the respondent number, whose a caveat is representing the respondent number 1, bar, the plaintiff before the trial court. Issue emergent notice to respondents number 2. Karkala. State will take notice for R3. R3 are Mr. Arvind, the state.
Yes, DPR, my lord. Chief Secretary, my lord.
All right. Then at HCGP to take notice on behalf of respondent number 3, Learned Counsel, to furnish copies. You copy of the petition to the respondent number 3. Relist this matter after 2 weeks.
Till date, my lord, not to.
No, your petition is liable to be dismissed straight away. Because notice is not issued, I am issuing notice.
Grateful.
Otherwise, it doesn't deserve any merit.
Yes,
Mr. Vardarajan.
Yes, I appear for the petitioner, who is the defendant in the suit. Now the rejection of my order application. Order 7 Rule 11 is what is challenged in this petition.
I am appearing for respondent.
Mr. Danappa, you are appearing for respondent?
Respondent, my lord.
Plaintiff? Yes, sir.
Plaintiff, my lord.
Yes, Mr. Vardarajan.
The defendant is the revision petitioner. Now, since the matter pertains to Order 7 Rule 11, plaintiff government is alone, so we'll decide the question.
Yes.
Therefore, kindly turn to the plaintiff itself. Kindly come straight away to the plaintiff, which the court gets at page 26.
Yes, 21. You want to come to
plate schedule is at
26.
Schedule 26.
Yes.
Schedule. Plaintiff A schedule property. Plaintiff's case is that his father Nanjundappa purchased a plaintiff schedule property through a sale deed dated 4/6/1945. That is about 6 acres 30 guntas. ಅಲ್ಲಿ 5 ಎಕರೆ 7 ಗುಂಟೆ ಅಂತ ಹೇಳಿದೆ, but in the body of the plaint it is stated it is 6 acres 30 guntas.
Yes.
Now, according to the plaintiff himself, that's out of the 6 acres 30 guntas, 1 acre 20 guntas, which is described in B schedule, is sold by plaintiff's father in favor of one Surya Narayana. Surya Narayana sold that to one Nanjappa. From Nanjappa, defendant purchased it, B schedule property. These are all available in the plaint itself, a reference to all the 3 sale deeds. Copies are also produced. Now
Yes.
9645 sale deed under plaintiff's father is purchased the property. The vendor is my grandfather, defendant's grandfather. Now, according to the plaintiff, let's after purchasing property and after selling 1 acre 20 guntas, that is B schedule property, plaintiff's father retained schedule C property, remaining extent. The grievance
That is 5
is
acres, 10 guntas.
the grievance is I am causing interference in that 5 acre 10 guntas C schedule property. Therefore, there should be a decree for permanent injunction. Now, therefore, the basis of the plaintiff's claim is that sale deed dated 4/6/1945. Now, kindly turn to page.
Mr. Vardharaj, your voice is breaking. Which page? Page number?
I have produced 44. 44. I am audible.
Yes, yes. Page 44.
Page 44.
Ah.
It's a very sharp read. I will read it. This is
What
the
is this?
basis of the plaintiff's suit.
What
This
is
is
this?
the sale deed. 4/6 sale deed.
Sale deed, 1945.
45, under which plaintiff's father has purchased according to the plaintiff property. It's a very short sale deed. That sale deed is only with respect to 1 acre 20 guntas. ಆ ಸೇಲ್ ಡೀಡ್ ಓದ್ತೀನಿ. 1940 ಜೂನ್ ತಾರೀಕು 4ರಂದು ಹೊಸಕೋಟೆ ಸೋಗನ್ಸು ಅನುಗಂಡನ ಹೋಬಳಿ ಅರಳಿಯಲ್ಲಿರುವ ದೊಡ್ಡ ಮುನಿಯಪ್ಪನವರ ನಂಜುಂಡಪ್ಪ ನಿನ್ನ ತಮ್ಮ ಮುನಿಯಪ್ಪನವರಿಗೆ, ನಂಜುಂಡಪ್ಪ ಇಸ್ ಪ್ಲೇಂಟಿಫ್ಸ್ ಫಾದರ್, ಮುನಿಯಪ್ಪನವರಿಗೆ ಡಿಟೋ ಗ್ರಾಮದಲ್ಲಿ ಮುನಿಯಪ್ಪನಾದ ನಾನು, ಮುನಿಯಪ್ಪ ಇಸ್ ಡಿಪೆಂಡೆಂಟ್ಸ್ ಗ್ರ್ಯಾಂಡ್ ಫಾದರ್, ಮುನಿಯಪ್ಪನಾದ ನಾನು ಬರೆಸಿಕೊಟ್ಟ ಖರೀದಿ ಪತ್ರ ಇದೇ ಅರಳಿ ಗ್ರಾಮಕ್ಕೆ ಸೇರಿದ ನಾನು ದಾಸಪ್ಪನವರ ವೆಂಕಟರಮಣಪ್ಪನವರಿಂದ ಖರೀದಿಗೆ ಪಡೆದು ನನ್ನ ಸ್ವಯಾರ್ಜಿತವಾದ ನನ್ನ ಸ್ವಾಧೀನಾನುಭವದ ಖುಷ್ಕಿ ಸರ್ವೆ 3ನೇ ನಂಬರ್ ಬೀಜಾವರಿ 6 ಎಕರೆ 30 ಗುಂಟೆಗೆ ಆಕಾರ 11 ರೂಪಾಯಿಗಳ ಜಮೀನಿಗೆ ಚಕ್ಕುಬಂದಿ, ಪೂರ್ವಕ್ಕೆ ಲಿಂಗಪ್ಪನವರ ಮತ್ತು ಸುಣ್ಣಕಲ್ಲು ಜಮೀನು, ಪಶ್ಚಿಮಕ್ಕೆ ಕೆರೆ ಅಂಗಡ, ಉತ್ತರ ಡಿಟೋ ಮತ್ತು ಖರಾಬ್ ಜಮೀನು, ದಕ್ಷಿಣಕ್ಕೆ ಸಿದ್ದಲಿಂಗಪ್ಪ ವೆಂಕಟೇಗೌಡ ವಗೈರೆ ಜಮೀನು, ಈ ಮಧ್ಯೆ ಇರುವ ಜಮೀನಿನಲ್ಲಿ ಉತ್ತರದ ಕಡೆ ಸುಮಾರು 1.5 ಎಕರೆಗೆ ಆಕಾರ ಸುಮಾರು ಸೋ. Therefore, what the plaintiff's father purchased is only 1 acre 20 guntas. It is apparent from the plaintiff's sale deed. Now, this 1 acre 20 guntas is described in plaint B schedule. Yes. According to the plaintiff himself, that B schedule property is sold by that Nanjundappa, plaintiff's father, in favor of Surya Narayana, who sold it to Nanjappa, from whom I have purchased it now. C schedule is what is retained by my grandfather while selling that 1 acre 20 guntas under that 1945 sale deed. Therefore, the plaintiff's sale deed itself says it is only 1 acre 20 guntas, and plaintiff further says that 1 acre 20 guntas is already sold away by his father. That's where is the cause of action for the plaintiff to file the suit with respect to C schedule property.
What is the relief, sir? Read the prayer, sir.
Permanent injunction. With respect to C.
He may be in possession. He may be only owner of one. According to you, the sale deed, which is executed by your grandfather in favor of the plaintiff's father of 1945, he is only getting 1 acre 20 guntas. That is your defense, which is shown in B schedule property. C schedule property remaining 5.5 acres. Please hear me.
Therefore, plaintiff government's admit.
Mr. Please hear. So, according to you, your grandfather sold only 1 acre 20 guntas to father of plaintiff, which is shown in B schedule property. According to plaintiff, he has stated so many things. His claim is that you should not interfere in C schedule property, which is 5 acre 30 guntas. He may be in possession. He may not be the owner. It is only a suit for permanent injunction.
No, minutes further, the basic this thing should be there in the plaintiff. Now, what though my father has purchased 1 acre 20 guntas,
his statement may be wrong. He is claiming permanent injunction.
Permanent injunction.
How the plaint can be rejected?
He is claiming permanent injunction on the basis of a sale deed. He says he is put into possession of the property under that sale deed.
Are you in possession?
That
Are you
sale
in
deed.
possession?
My grandfather was the owner.
Are you in possession of C schedule property?
C schedule plus B schedule, both.
All right, enjoy it. His suit will not be maintainable. Let the court frame issues.
C schedule retained. After selling,
Mr. Varadaraj, your bandwidth is not good and internet connection, you're on and off. I can't hear half the statements made by you. Intermittently, you're going off.
Then may make this submission, Miller. The matter
Yes.
is posted in the trial court on 2nd March.
Yes.
This will be called on 20 Again, I am inaudible.
Sir, you're not audible still. I'm unable to hear what you're saying. Only I could hear that the matter is posted before trial court on 2nd March. After that, what did you say?
Just next, the matter is posted. Master is posted on 2nd March in the trial court.
Yes.
The matter may be called on 28th. He has filed wakalat yesterday, it appears. Danappa. I will serve a copy on him.
ನಿಮಗೆ ಕಾಪಿ ಬಂದಿಲ್ಲ ಮಿಸ್ಟರ್ ದಾನಪ್ಪ?
ಸರ್ ನಮಗೆ ಕಾಪಿ ಬಂದಿಲ್ಲ ಸರ್, ಕಾಪಿ ಬಂದಿಲ್ಲ ನಮಗೆ.
ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿರಲಿಲ್ಲ. ನಾನು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮೆಮೊ ಹಾಕಿದೆ CRP ಹಾಕಿದ್ದೀನಿ ಅಂತ. Then Danappa has filed wakalat. Of course, I have no objection. Then I will serve a copy.
ಬರ್ಕೊಳ್ಳಿ. Learned counsel Sri Varadarajan submits that he will serve a copy of this petition to the learned counsel for the respondent who is a plaintiff before the trial court, namely Sri learned counsel Sri Danappa, who is present through video conference. Full stop. Relist this matter on 28th February.
Very good.
My lord, 28th February is matter on going on trial court, my lord. Any other date, my lord? 28 to 28 my lord.
28
much of
28 2 ನೇ ಕೊಟ್ಟಿರೋದು ತಾವು.
ಹೌದು. ನಿಮ್ದು ಮಿಸ್ಟರ್ ವರದರಾಜನ್, you have to get right, set right your internet connection.
I don't know. Today it is causing some problem. There was no problem till today. Even morning I attended 2 matters. There was no problem. Absolutely. I just
now you are audible. Now you are continuously audible.
I switched to the other instrument.
All. Please maintain this instrument even on the next date if you are coming online.
Thank you. Thank you.
Number 15, Arjun. Junior hearing, serial number 15, Bagindra Hada.
15 Arjun aita. Yes, Mr. Raghavendra Rao. Yes. You are the petitioner.
Yes.
In cinema matter, no?
Cinema matter. But petition.
Yes, sir.
The owner of the theatre in Davangere.
He is Rudra Basuraj.
May I make one submission in this matter?
Rajkamal Enterprise. Yes, sir.
Please, Lord, sorry to interrupt. With the very same serial number 16, Lord, on behalf of respondent number 3, I filed my caveat. No caveat is shown. Caveat is not put up. I am the stakeholder in this matter. I am in possession of the subject.
Mr. Jairaj.
Please, Malaj.
Caveat put up agilwalla.
Caveat put up agila, Malaj.
No, there is no caveat to be put up.
I have filed caveat.
Today, it is Deputy Commissioner.
It is a deputy commissioner
who has to answer this claim.
and your
And
petition
more-
is against the order passed by the DC. All right.
But your lordship kindly say, petitioner is the owner of Aruna.
Aruna Theatre.
Aruna Theatre is down. The license is obtained by the petitioner only.
Petitioner ಅಂತೀರಾ ನೀವು, that is a partnership firm. Who are the other partners?
Other partners are, I have to do the partition.
Whether respondent number 3 is one of the partners.
No, he is not. It is not his case that he is a partner.
Who are the other partners?
Other partner, your lordship kindly say annexure. Here I have produced the partnership team. All brothers. Portrait, Siddharth, Gangadhar, Shivashankar, Shivkumar, Putra Swaraj, and Jire.
Putra Swaraj ಎಲ್ಲಿದ್ದಾರೆ ಇದರಲ್ಲಿ?
Putra Swaraj is last but one.
7. Serial number 7. And what is the name of respondent number 3? Dinesh. He is not a.
He is not. It is not his case that he is the partner. Now, my lord, the license is also in the name of this party.
Initially.
No, even now. Even now it is in the name of the petitioner. But the license expired by September 2021. Thereafter, my lord, in view of this existing pandemic situation,
Yes.
theatre cannot be run profitably. We gave a specific.
Madam, you are appearing for the first and second respondent. Yes, your copy has been received. Yes, sir.
We gave.
Madam, you sit down.
We gave a specific license for the deputy commissioner, not to renew the theatre.
Not to renew.
Not to renew. Respondent number 3, who has no locus standi also, according to him is a fraudster.
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 According to you.
Yes, according to me.
So you give a letter to them not to give
Now
license to him.
We got the information that he is likely to approach the deputy commissioner seeking renewal license on behalf of the firm, even though he has no locus standi. Based on that, your lordship kindly deputy commissioner has adjudicated the matter, and your lordship kindly see in page 29 annexure F.
Annexure F.
Annexure F in page 29. He has passed the order. Kindly see page 30. The reasons that are given by him for rejection are page 30. Last 4 lines.
ಎಲ್ಲ ಆದೇಶ
ಆದೇಶ ಮುಂಚೆ 4 ಲೈನ್.
ಆದೇಶಕ್ಕೆ ಮುಂಚೆ 4 ಲೈನ್.
4 ಲೈನ್. ಆದರೆ ವಾದಿಗಳು ಚಲನಚಿತ್ರ ಮಂದಿರದ ಮೂಲ ಮಾಲೀಕರು ಆಗುವುದಿಲ್ಲ ಹಾಗೂ ಮೂಲ ಮಾಲೀಕರಿಂದ ಮಾಡಿಕೊಂಡಿರುವ ಬಾಡಿಗೆ ಕರಾರು ಪತ್ರವು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸುತ್ತಿಲ್ಲ. ಅಲ್ಲದೆ ಮೂಲ ಮಾಲೀಕರಾದ ಪ್ರತಿವಾದಿಗಳು ಚಲನಚಿತ್ರ ಮಂದಿರ ಪರವಾನಗಿಯನ್ನು ಪ್ರತಿವಾದಿಗಳ ಮನವಿಯನ್ನು ಪುರಸ್ಕರಿಸಿ ಈ ಕಡೆದಂತೆ ಆದೇಶ ಅಂತ his application seeking renewal came to Egypt. Thereafter,
So this is by the
deputy commissioner.
Yes.
That is on 21/9/2021.
R1.
Yes. Then kindly see in page 31.
9.
In page 31, annexure G.
21/9/21.
Yes. 22/9/2021.
Yes.
That is the in page 31 annexure G. Deputy commissioner himself directs the Tahsildar in view of the fact that the license is not renewed, you see that no cinematographic exhibitions are made in Arunachal. That is annexure G.
Yes. Yes.
Thereafter, my lord, after this serving this order,
yes,
against the rejection of this application under
under the provisions of Karnataka cinema. Then there is an appeal provision that are provided in section 10 before the regional commission. She files a belated appeal and he does not serve a copy of his appeal to the petitioner, suppressing all these material facts. He approaches this Honorable Court, making certain wild allegations in this regional commissioner. He is not hearing the matter, and he obtains an interim order stay. Now, immediately after knowing that this kind of situation, petitioner entered appearance.
Yes.
And has filed detailed objections before this Honorable Court and sought for vacation of the interim order.
Finally,
Initially,
the writ petition came to be disposed of. Direct empty was appeal.
That matter is pending with the appellate authority. No interim order is granted.
Yes.
Despite that matter, Deputy Commissioner is allowing screening of the movies, even though we gave a specific representation. You will not be kindly say specific representation we given. Annexure N may be kindly see annexure 48, Influence 48.
You gave a representation.
We gave a representation. Even though we gave a representation, he is not implementing his own order. Illegally, he is permitting respondent number 3 to screen the movies.
The petition is for mandamus.
Mandamus.
Now, in view of the order passed by the Deputy Commissioner,
yes,
that he's now not given any license to the respondent number 3, and pursuant to his appeal pending. Now you have given a representation and they have not considered.
They are not, no, they are not only considered. Now, in view of this, his own order, he cannot not consider the representation. His duty, statutory duty under the Act, because he is the licensing authority.
Read it.
Section 4 of Section 4 of Karnataka Cinemas Regulation Act.
Mr. Jairaj, you are able to hear learned counsel?
I am.
If you are here, you can make your submission. We'll hear
Please.
you.
Please.
Yes, sir.
Lords.
Kindly see section 3. Section 3 of the Act.
Licensing authority.
The authority having power to grant license under this act shall in every district be the district magistrate. In this section, district magistrate is the deputy commissioner, exercising the powers of the district magistrate. So he is the licensing authority. And kindly see section 4. Same as otherwise provided in this act, no person shall give an exhibition by means of a cinematic elsewhere than in a place licensed under this act or otherwise than in compliance with any condition or restriction imposed by such license. So license is a must by the licensing authority. And he himself has rejected the license request made by respondent. And he is refusing to implement his own order. But he is violating the rule of law.
So according to you, there's a violation of section 4.
Section 4 and basic rule of, he is the authority who is supposed to see that without license, no cinemas are exhibited. He himself is flouting his own under section 4 and he is permitting it. This is what exactly is happening. And the appeal of respondent number 3 is pending considering before the appellate authority. Kindly see the order passed by this summons.
That may not be in dispute.
Yes, there is no dispute.
That may not in dispute. He filed a writ petition stating that his application is not considered. This court passed an order, disposed of the writ petition. giving directions to the appellate authority to consider his application and pass orders, which is pending adjudication. Yes, sir. Mr. Jairaj.
Please, my lords.
Ah.
My lords, my first submission is, my lords, I have not suppressed anything. And I have also specifically stated as to why the subject writ petition was preferred. My lords, prior to the appeal not being considered. My lords, by virtue of the order passed by the Deputy Commissioner, my lords, I was not able to run the theatre. And more importantly, my lords, I am in possession of the subject scheduled property from the past 10 years. The lease has not been.
As what?
My lords, I'm exhibiting the cinemas. There is a oral agreement. I'm a tenant of the scheduled property. And I have been exhibiting cinematography films. The lease, my lords, is not terminated in accordance with law. I have also, my lords, by virtue of the high-handedness of this.
So the lease is given to you by whom?
By the very owner, that is the petitioner herein.
Okay.
That is the petitioner herein. And my lords, both of
Which
both
year
of
is the lease?
2000. I'm in possession from the year 2012. My lords, also due to the high-handedness of this petitioner, my lords, having causing threat to my possession and exhibiting the cinema, I approached the Honorable Trial Court and have obtained an order.
Whether you have license now to run the cinemas.
My lords, that subject dispute is pending consideration before the regional commissioner. I have challenged the very appeal and I have also obtained an order of injunction.
So you are admitting to the fact as of now you do not have license to run cinemas. You have filed a petition which is pending. Correct?
Yes, my lords. Yes, my lords. And the license was given to the property. And I was the very signatory to the, my lords, whatever the payment that was made so as to obtain the license. And I have entered into, my lords, an agreement to renovate the cinema theatre. And I have invested a lot of expenditure towards the same. Having, my lords, the fact that I have obtained an order of injunction as against this petitioner, he has not taken any action to vacate the same. It is still in operation. With regards to the very same subject scheduled property. And my lords, the only point on which the Deputy Commissioner, having rejected the license, is that there is no lease agreement between the petitioner and myself.
All right.
And only upon his oral objections seeking not to renew the license toward the subject cinema, the same was rejected. That is challenged and is pending. Also, my lords, the very fact.
All right. So now, Mr. Jairaj, admittedly, you do not have license. You may be claiming as a tenant.
Yes,
you may be running for the past 10 years.
Yes, ma'am.
There are certain rules and regulations which you are bound when you are going to apply for license to run the cinemas.
Absolutely.
You go and prove that, produce it, and then you run it.
I have, my lords, indeed, I have produced all sort of documents before the regional commissioner to suffice my case, my lords, as to the payment.
Rejected, sir. Initially, it is rejected.
Yes, initially it is rejected.
Yes, you have challenged it.
Yes, ma'am.
In appeal, which is pending.
Yes, ma'am. Yes, ma'am.
Yes, that is all is your case.
That is all is my case.
Why he has to come to the court for you to consider? No, this is not unfortunate. This is going on everywhere. This is becoming the norm of the day. The illegality is becoming the norm of the day. We all know why he is allowing respondent number 3 to run. When already he has given a letter in advance to you, he may be claiming and he may be seeking license, do not give, which is acknowledged by you. On an application filed by R3, if the license is rejected, he goes and files an appeal which is pending, comes to High Court, nothing is granted to him and directed to go back. You are still not doing your duty. You are unfit to be in the job. Your officer is unfit to be in the job. What is the duty, sir? Under the act? What is the duty of the officer under the act?
Section 4 specifically says he must ensure that the cinematography movies are run only by a license. Section 4 specifically says,
yes,
unless there is a license under this act,
correct.
He is the authority who has to grant the license.
What happens in there is a violation? What should be done?
Section 15 is there. Penalty.
You should give the ammunition to us to pass order, Mr. Raghavendra Rao.
Yes, section 15 is the
Section
15 is the penalty. Section 16.
1-5.
6-1-6.
1-6. Yes, penalties.
If the owner or person in charge of his unit uses the same or allows it to be used, or if the owner or occupier of any place permits the summons that place to be used in contravention of the provisions of this act or of the rules made thereby, or any of the conditions and restrictions upon or subject to which any license or permission under this act, or any of conditions or restrictions prescribed in an order under section 20. Or if any purpose contravenes the provisions of section 11 or any of the provisions of this act or rules made thereby, he shall on conviction be punished with fine which may exceed 1,000 rupees, or in case of continuing offence with a further fine which may exceed 100 rupees for each day to which the offence continues. Where after a prosecution for an offence under section 1 has commenced, the license examiner has reason to believe that the holder of the license is again committing of an offence or continues to commit it. The licensing authority may or by notice warn the holder of the license, notice to continue the offence. If the holder of the license persists to commit the offence, the licensing authority may suspend the license pending result of withdrawal for a while. He is the person.
This is for your violation, sir.
For our violation. Under this
Our
act,
violation gain ಮಾಡ್ಬೇಕು ಅವ್ರಿಗೆ ಅದನ್ನ ಹೇಳಿ.
this is the rule of law. He is supposed then when some disciplinary action must be initiated against him for not implementing the provisions of the act. It is violation of rule of law.
Yes, madam. Not able to hear you. No. Tap it. Tap your mic, madam. Yes.
There is a derivation of duty as far as the commission is concerned. We definitely recommend that.
Shall I note your submission? Madam,
No, I'm
we have to.
Because at the end of the day, your lordships, we are as court officers, we have to ensure that some work is done by somebody. They can't keep violating their own norm. They can't just follow a blind eye. In fact, as far as our office is concerned, even we are tired of counseling them and telling them follow the rule of law.
The submission is noted, madam. Then maybe you will not be here tomorrow, representing the state. What, Mr. Jairaj? If the submission of the HCGP is noted, she will not be here tomorrow, which will be detrimental to you.
That's right.
No, but why should the direction be given? It is your duty. It is a bounden duty of the officer that simple logic and the rule of law is if the person doesn't have license, same is not approved and rejected by the authority, which is pending consideration. How you can permit him and how you keep quiet? That shows volumes about how he is running. High-handedness is apparent on the face of the records. What are you seeking now, Mr. Counsel?
Start for any directing response to stop the illegal stealing of the response. So, in page 17, paragraph 26 is the
Anything else you want to add, Mr. Jairaj?
Maloj, I'll make only one submission, Maloj.
Yes,
If this matter could be called on Friday, or Maloj, even before that, Maloj, ultimately, Maloj, it can be heard together. Instead of Maloj considering the interim prayer, and it can be disposed of in accordance with law. Maloj, because only sole reason my grievance is, Maloj, pursuant to this interim order, I won't be able to exhibit the cinemas. That's the
Absolutely
only
right.
Malaj,
Absolutely. We'll consider on Friday the main matter. We'll pass interim order now.
Malaj,
Any further delay is this court adding on to the actions of the respondent number 1. Any further delay by this court means that this court is also hand in glove with the respondent number 1, who is not doing his duty. This court will not shirk its responsibility from doing its duty.
Yes, yes, Malaj, yes, Malaj.
Yes, take down. Shall I take it that you have taken notice for the respondent number 3?
It can be. Yes, yes, I take it.
Heard, learned counsel Shri Raghavendra Rao K. Sir, you have been designated as senior counsel? Huh? Not yet. Not yet. So, Shri Raghavendra Rao, learned counsel for the writ petitioner. Full stop. Learned counsel Shri D.S. What is your name, sir?
Sandesh CR.
Learned counsel Shri Sandesh CR, who has appeared through video conferencing on behalf of respondent number 3, submits that though he has filed a caveat, his name is not shown in the cost list. However, on verifying and the records, the caveat petition so stated is not put up, and no such caveat petition is annexed to the file of this case. However, since learned counsel has appeared on behalf of respondent number 3, he has been heard in the matter. Full stop. Office is directed to show the name of Shri Sandesh CR and D.S. Jayaraja.
Yes.
And D.S. Jayaraj, learned counsels appearing on behalf of respondent number 3. Learned HCGP waives notice on behalf of respondent 1 and 2. Have you received copies? Yes. Full stop. Petitioner is a registered partnership firm having its office at Davangere. Full stop. It is involved in the running of cinema business in the name of Aruna Theatre at TB Road, Davangere, and exhibiting cinematograph films. Full stop. The petitioner had license which was renewed from time to time. The same expired on 22/9/2020, which was lately renewed till 21/9/2021. Full stop. It is submitted by the counsel for the petitioner that the petitioner firm gave a representation to the respondent number 1 on 5/8/2021, informing him that the firm is not seeking further renewal of the cinema license in view of prevailing pandemic situation. Full stop. However, thereafter, the firm suspected that the respondent number 3 may approach respondent number 1 with a false representation seeking renewal of license in the name of Aruna Theatre. And sought for a prayer not to entertain any request made by respondent number 3 to respondent number 1. Full stop. As expected by the petitioner, respondent number 3 gave a representation to respondent number 1 on behalf of Aruna Theatre seeking renewal of license. Full stop. According to the petitioner, respondent number 3 is neither the partner of the firm nor connected with the petitioner firm, and therefore he is a stranger, and the license to run the cinemas at Aruna Theatre cannot be granted to the respondent number 3, which was the specific contention of petitioner while giving a representation to respondent number 1. Full stop. The respondent number 1 in case number ENT capitals colon CR capitals -08 colon 2021 -22, after hearing the petitioner and respondent number 3, passed an order on 21/9/2021 refusing to renew the license on the representation given by respondent number 3. It was specifically held by respondent number 1 that respondent number 3 is not the owner of Aruna Theatre, and since he had not produced any lease deed to show that he is in lawful possession of the theatre as a tenant under the petitioner firm, the renewal of license in favor of respondent number 3 came to be rejected. Full stop. Next paragraph. Aggrieved by the said order passed by the respondent number 1, an appeal came to be preferred by the respondent number 3 before the regional commissioner Bengaluru, the appellate authority under the act, challenging the order passed by the first respondent number 1. The said appeal is still pending adjudication. In the meanwhile, since no orders came to be passed in the before the appellate authority, the respondent number 3 preferred a writ petition before this court in WP 18575 of 2021 and obtained an ex parte interim order in his favor on 12/10/2021. Thereafter, by order dated 3/12/2021, the said writ petition came to be disposed of by this court with a liberty to the petitioner therein, the respondent number 3 herein, to prosecute the appeal already filed before the first respondent, and all contentions of the parties were left open. The further direction was given by this court to the first respondent or appellate authority the appellate authority to consider the application filed by the third respondent herein and pass necessary interim orders, if any, without being influenced by the orders passed by this court. Full stop. On 6 December 2021, the petitioner herein made a representation to the Deputy Commissioner, first respondent, who is the licensing authority, bringing to the notice of the disposal of the writ petition and the illegal running of cinemas by the respondent number, illegal running or exhibiting of movies bar cinemas by the respondent number 3. And sought for action to be initiated against the respondent number 3 for exhibiting the movies illegally without there being any license or authority. Correct? What happened to that letter of yours on 6 December? Any reply?
doesn't say anything and he allows it. He doesn't take any action.
Pursuant to the said representation made by the petitioners, no action has been taken by the respondent number 1 herein, aggrieved by which the petitioner is before this court in this writ petition seeking for a writ of mandamus against the respondent number 1 to exercise his statutory power vested in him as per the Karnataka Cinemas Regulation Act and the rules contained therein. I have heard learned counsel for the petitioner, learned counsel for the respondent number 3, who is the contesting party, and the learned High Court government pleader on behalf of respondents number 1 and 2. Having heard the learned counsels for the parties, it is apparent on the face of the records and the submissions made by the learned counsel for respondent number 3 that admittedly he does not have a license to exhibit the movies in Aruna Theatre, PB Road, Davangere as of now. So also his application for grant of license on exhibiting movies before the concerned authority also came to be rejected, which is not disputed by the learned counsel for the respondent number 3. Full stop. The fact that aggrieved by the rejection of the license in favor of respondent number 3 has resulted in the filing of an appeal as contemplated under the Act before the appellate authority, which is pending adjudication. Full stop. It is also a fact that the respondent number 3 approached this court and this in a writ petition bearing WP number 575 of 2021, which came to be disposed of on 3rd December 2021, with a direction to the appellate authority to consider the case of the respondent number 3 in accordance with the law. Therefore, it is apparent that as of now, the respondent number 3 does not have a license to exhibit movies in Aruna Theatre, PB Road, Davangere. To stop. Despite bringing these facts of disposal of the writ petition and no license having been granted by the concerned statutory authority in favor of respondent number 3, the respondent number 1 has not acted or performed his duty in accordance to the provisions of the Act or the duties vested in him as per law. Therefore, it is apparent on the face of the record and the submissions made by the learned counsels that the screening and exhibiting of movies in Aruna Theatre, PB Road, Davangere by respondent number 3 or any person on his behalf is illegal as no license has been granted, which is presently the subject matter pending before the appellate authority. This being the case, it is incumbent on the respondent number 1 and 2, who are the statutory authorities, to take immediate legal action if any such movies are exhibited in Aruna Theatre, PB Road, Davangere, pending disposal of this writ petition. Full stop. It is sad to know and is appalling that the petitioners, who are the owners and license holders initially, have to move this court for a direction to the respondents 1 and 2 to perform their official duty in accordance to law. there need not be a direction. Full stop. The petitioner should not be driven to approach the court for a direction to be issued to statutory authorities and officers who are holding statutory posts as it is for performance of their duties, official duties in accordance with the law. It is incumbent on them to do their duty in accordance to law and prevent any illegalities. In the present case on hand, despite there being no license granted in favor of respondent number 3 and the appeal still pending before the appellate authority, the writ petition having been disposed of by this court without granting any relief in favor of respondent number 3, it is apparent on the face of the records that something is seriously wrong in the functioning of respondent number 1 and 2 in allowing the screening and exhibiting of movies in Aruna Theatre, PB Road, Davangere, without there is no license being granted for the same. Full stop. Accordingly, I'm of the opinion that the petitioner deserves to be granted an interim relief in this matter until the disposal of the writ petition. Hence, I pass the following order. The respondent number 1 and 2 shall stop the illegal screening or exhibiting of movies by respondent number 3 in Aruna Theatre, PB Road, Davangere, if it is found that there is no license granted in his favor, or if any order is passed there is no order passed by the appellate authority. If Bedama shall stop the illegal screening. Yes, Mr. Counsel, Jairaj.
Please, my lords, please, my lords. The matter has been argued.
License as of now, are you agreeing to this fact?
My lords, the matter has been posted for orders. Both of us have argued and it is posted for orders.
All right. And it is also fairly submitted by learned counsel for respondent number 3 that though he has argued the matter before the all right. What have you written? Last. Before that, read the before sentence. Aruna Theatre, PB Road, Davangere. Better. Forthwith, stop the screening of movies forthwith and follow the due process of law as contemplated under the Act. Yes, sir. Mr. Jairaj, I have passed an order to stop the screening illegally forthwith. You can agitate the matter before the appellate authority. If you are given license, you can run it.
Please.
Finally, I think you should take action against these officers who are causing nuisance. Yes, Mr. Somshikar. Appealing for petitioner, sir? Yes.
This is a case where the petitioner was granted an excise license, pursuant to which, before he got a license, he filed an application for shifting of the excise, the license which is likely to get. Based on which, he files an NOC before the Gram Panchayat for getting an NOC for shifting.
Who the respondent 4?
Respondent number 4.
Yes.
Then it approaches this court for.
Who are you? Who are you?
I am. We are the villagers, who filed an objection for shifting of the license.
So all the petitioners are villagers.
Villagers,
of Hunse Halli, is it? Hunasena Halli.
reason I had
So that is where he is seeking for transfer.
The reason is this. Under clause 12, rule 12, Manoj, the maximum, the population is 1,200.
Yes.
For 1,200, Manoj, only one license can be granted as per the excise fees. Now to circumvent that, Manoj,
What is the population?
1,200, Manoj, in this village. And there are already existing 3 licenses. So he knows that if he applies for this village, then he will not get license. So he applies for some other place.
Oh.
Then before he gets the license, he files an application for transfer, which is rejected. He files a writ petition, subsequently withdraws the writ petition. Then he gets a transfer. Manoj. Totally, Manoj, misleading, abuse of process, contrary to rule 12.
He files a writ petition before this court.
This court and withdraws, Manoj.
Where is that?
That your worship may kindly see, Manoj, that is at page number
18970.
103, Manoj. Operative portion of the order. 102, Manoj.
Yes.
103.
Yes.
Learned counsel appearing for the petitioner submit that during the pendency of the license has been granted by the deputy commissioner. No problem, let him continue the license. Subject to the condition, in the event that the resident would complain, the same would be withdrawn unilaterally. In the light of the license being issued by the deputy, petition has rendered infructuous. What is interesting, Manoj, Rashmi page 103. If what is challenged is 16/10/2021 is the impugned endorsement where the Gram Panchayat rejects the shifting. That has become final. Now what he does after this is withdrawn on December 2021.
No, what is challenged before the writ court in the earlier writ?
16/10/2021.
16/10/2021.
That is the order by the Gram Panchayat rejecting his shifting. So, not granting NOC for shifting.
Yes.
He challenges it, he withdraws it.
Yes.
Now after that, Manoj, Annexure A is passed, saying permitting shifting by the excise commissioner.
No, even in this order, subject to the condition that in the event any of the residents complain, the same would be withdrawn unilaterally.
Correct, that is also stated there. That I have bowed on the there is already a complaint, there is a rejection. In spite of this order, as well as he's got an impugned order in the month of Annexure A.
So this order is on 21st December.
21st December.
After that, you have made an objection. You made a representation and objection
Yes,
on behalf of the villagers.
Please, Manoj. That is that, Manoj. Your worship, it is on, Manoj, 26, page 105, Manoj.
Yes. What is the date of this?
The date of that is date of 30th?
30th December.
30th December. The seal is there, 30th December 2022. One thing, first aspect, rule 12 does not prohibit. And what is interesting, your worship, is license, just give 2-3 dates, His license is dated 30th June, 30th June 2021. His application for shifting is 1st April 2021. That means 2 months prior. 2 months prior to granting license, he files an application for shifting. That means his intention was to get.
So before the grant of license itself, he is sought for shifting.
Then Gram Panchayat rejects his application. He challenges his withdrawal, saying that subject to the complaint. There's already a complaint, there's already a rejection also. Then without disclosing this fact, he goes and gets a shifting order.
Yes.
And a population of 1,200, there are already 3 excise licenses. This is next to Andhra Pradesh border.
Yes.
There's a prohibition in Andhra Pradesh. Every night, people come from the border and all the liquor licenses are open throughout. And it's creating a nuisance to the residents.
Yes. Who's appearing?
Matters coming for admission.
Yes, madam.
First time.
So blatant violation of the rule. Again, second time. You want to only favor him and then you are giving such orders even before grant of license, he is shifting. And it is not even permissible as per your rule and the conditions imposed.
And in fact, my lord, your lordship, can you see his prayer in the writ petition, earlier round of writ petition, that is at page number 60, my lord.
Page number
59 and 60.
Yes.
First prayer, issue a written nature and quashing the endorsement dated which was rejected. Then prayer number 2, my lord. Issue a mandate directing third response to issue NOC in favor of the petitioner to shift license on to. So therefore, my lord, he withdraws this petition saying that it is a complaint. So if the shifting has been rejected, no NOC. In spite of that, my lord, he withdraws and gets a license for shifting.
Recording. Third learned senior counsel Shri Shashikiran Shetty on behalf of Somashekara KH for the writ petitioner. Stop. Issue emergent notice to respondent number 4. What about this excise inspector Gauri Bidanu?
The state
State will take for 1, 2, and 3. Issue emergent notice to respondent number 4. Learned HCGP waives notice on behalf of respondents 1 to 3. Copies have been given to you, madam. 1 to 3. Full stop. Annexure A is the now shifting, is it?
Only shifting. He can carry on his business as per Annexure B license, my lord. We are not.
So Annexure B is the license at which place?
That is at
Gauri Bidnu.
Chikballapur.
Vapasandra. BB Road, Vapasandra, Chikballapur town.
Please let him carry on his business as per the license.
Anyway, you are not challenging Annexure
I'm
B.
not challenging Annexure.
So Annexure A is the shifting.
Which is on 17th January 2022.
There shall be stay of operation, stay and the operation of the order dated 17/1/2022 made in so and so, passed by the second respondent void Annexure A. Full stop. Till next date of hearing. Madam, these kind of things, I don't understand how the government is functioning. It's clearly apparent what is happening. Any blind man also will know how you are allowing them and what is happening. The villages, residents, even according to the rule, there is a clear-cut guidelines that what is the population, how many licenses. What is this? You'll have to come down heavily. You better instruct your officer.
And the modus operandi, my lord. The respondent 4 knows he cannot get it.
No, it's very apparent on the face of the record.
And before the court also,
High stakes would be involved, if I'm sure.
in the border of Andhra Pradesh, there's no liquor license over there. Every night, people from Andhra Pradesh come here, which is a bordering village. And it's, for the villagers, it's become.
Who is this respondent number 4?
He's in Bangalore. He got a vast number of exercises everywhere. He's able to.
He must be a high-handed person. No doubt. It is apparent. He makes it very obvious. He can get anything. You can get a transfer before granting of license. Please don't ridicule the system. Yes. Good. Yes. Yes, Mr. Janardhan. You've been sitting here since morning.
I appear for the respondent.
Huh? Yes, Shailesh.
Lord, I appear for the respondent.
Suit for ejectment. That this is that 106 TP Act. Yes. The 106 TP Act. So I think last time it was urgent for you both to decide whether you can. So they changed the lawyer. Then it may not be in good taste for the client. What was suggested by your friend, Mr. Madhusudan Rao? Probably.
I
What
did
Mr.
not, my lord, I did not know about the, what transpired on the last occasion. What I was told was I had actually a open heart surgery. So we
Yes,
made a
yes.
mention that it can be adjourned for a month. So currently I'm in a position to make my submission, my lord, but I did not know so far what Madhusudan had an arrangement. So far
No,
as
no,
this
he did not have an arrangement. He was
whether
arguing
he
the
had any
matter.
arrangement with the client or not, I do not know.
No. He was arguing the matter tooth and nail. It was suggested by the court to both Mr. Janardhan and to Madhusudan to verify with their clients if you are wanting to settle the matter amicably.
Well, Lord,
All right. Now that issue
I
is
did
over.
not know about it.
Doesn't
Honestly,
matter.
I did not know, my
That
lord.
issue is over. Now that you are before the court, you can address your arguments or make your submission.
Please, my lord.
Yes, sir.
The policy to show that yes. Not doing
In the shop, any. Your colleague is not here. So I have to do the postman's job. He says that it is under lock and key. He is not operating the shop.
What reason is locker these are not been suggested even though only technical reason I have found the and the trial board regards two issues. One is denied the jurisdiction for flat on time, and another issue is notice termination of duties. But even though it is correct, second part is concerned that the duties has not received or it was not supposed to be set up. Otherwise, also 111A and 116 is coming to that. There is no notice necessary. But and also the second proposal for the even if it is accepted or it is paid.
111. And
116.
Ah.
After the 111 effects of time, but if the 116 is backed out, the team will give a consent. And for continuation of the tenancy, like tenancy will be if the monthly tenancy will be shop or otherwise under service is manufacturing.
Yes.
Yearly tenancy.
Yes. 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 What is it already? No, to the court. You have given to the court.
The memo I filed on 17 January 2022.
Yes. What is the time period you are willing to give for him to vacate?
It was from 1989 was 11 months plus the period. But it passed cars are not there. It should be like the conditions. But 107 is there. 107 is there, it is beyond 1 year. Beyond 1 year, it should be first registration. Within 1 year, that should be by delivering portion or by notification.
No, no, what I said was, now you have suffered a decree of dismissal of your petition. Now you're in appeal, HRRP. This is division, right? This is CRP. All right. Now, is there any time limit you are willing to grant him to vacate? Yes, Mr. Shailesh.
My Lord, so far as time is concerned, your lordship may have it on Monday or even on Friday. I will make my submission because I'll try to get my party and convince him to, if he can vacate this premises, some time can be granted. Friday
No,
or
now,
Monday.
now it is apparent by the photographs produced by Mr. Counsel that your client is not in physical possession of the property.
Please.
We don't know whether that is I'm not giving any opinion on that photographs produced by your friend. However, it may be the truth. If you are not in possession, I think it is good for you to take time and vacate the premises. You can suggest it to your client. We'll give one more opportunity to you because you have now come on record. Probably the same was given to your predecessor, Mr. Madhusudan Rao, which was not in good taste of your client. If he wants to again change you, then it is your lookout.
I understand, my lord. That's the reason, my lord, if the premises is vacant.
Is it okay if you post it on Monday?
My lord, if premises is vacant, granting time doesn't arise, he can as well take the premises immediately.
Correct.
So only thing is, I would like to verify if the premises is working and if there is some reasonable time can be granted, that I will ascertain. That's the reason I'm requesting your lordship to grant me some 3-4 days time. I will in the meanwhile find out.
Yes. All right, time will be granted. No problem on that. But this should not become a ruse for your client to move on.
No, I did not know, honestly, my lord.
Changing the lawyers.
No, I did not know. Honestly, I came to know about it only today, my lord. That's the reason. I am taking serious reservation with my client so far as this matter is concerned, because normally I don't appear where somebody else has appeared. I was not instructed on that.
It is not in good taste.
No,
it is
definitely,
not in good taste, at least for the
it is definitely
advocate
not in
fraternity.
good taste. I understand, my lord.
Yes, sir.
Electricity but I suggested act even you are not keeping things on vacant and no purpose to be served. But there's not totally
All right, Mr. Silas is now come on record. We will give him also one opportunity. If he comes out with voluntarily vacating, very well and good. Otherwise, this court will dispose of the matter on merits. Yes. Yes. When do you want it, Mr. Shailesh? You can choose the date.
Monday, my lord. I'm not seeking for a longer time. Any day on Monday or so, it can be taken up.
All right, we'll have it on Wednesday.
Please, my lord. Not
23rd.
23rd. It may be taken up on 23rd.
23rd, madam. Yes, sir. Is it okay for you? Wonderful. Learned Counsel for the respondent, Shri Shailesh SK, is present to video conferencing. Learned Counsel for the petitioner, Shri Janardhan, is present physically before the court. Learned Counsel for the respondent submits that he will inquire with his client, namely the respondent, if he is agreeable to vacate the premises, the petition premises, which is in question. Hence, this matter is adjourned to 23rd February to facilitate learned counsel for the respondent to ascertain if there is any amicable settlement that could be arrived at between the petitioner and respondent, petitioner landlord and respondent tenant. Full stop. Learned counsel, Shri Janardhan G has filed memo 4 photographs showing and bringing to the notice of this court that the petition premises is under lock and key and the respondent is not in operating the shop or running the shop as on date. From as on date andre now or from when? From for quite some time. Full stop.
Lord, I beg to appear for the petitioner. Lord, yet another landlord-tenant dispute for my lord's kind consideration.
Yes.
The petitioner, my lord, is a landlord. Lord, they are aggrieved by the order passed by the rent revision court. Inasmuch as, my lord, having reversed the judgment passed, my lord, under section 27(2)(r) of the Rent Act. My lords, the judgment of the Honorable Court of First Instance is at page 37.
Yes.
Lords, if my lords were to refer the cost title, my lords, just to narrate the facts, my lords, and introducing the parties. My lords, the lessor, my lords, was Mr. K. Bhaskar Rao.
Yes.
But Mr. K. Bhaskar Rao, who is no more, my lords, was the original lessor. My lords, the deed of rent, my lords, is of the year 1974. It is 1st of September 1974, my lords.
Registered lease deed?
My lords, it's an unregistered document. Whereby, my lords, two small commercial tenements had been let out. Now, my lords,
who's appearing for respondent?
appear for the respondent number 1 to 3, Lord.
All right, you are ready in the matter?
No, please, no.
Yes.
Now, my lords, the subject matter of this agreement were, my lords, two small tenements having separate municipal numbers. The rent which was agreed upon, my lord, was rupees 15 per month, 1/5, which, my lords, surprisingly was never revised. And, my lords, the specific contention is of the petitioner, my lords, is rents have remained unpaid from the year 1994 onwards. And, my lords, that they have deviated the purpose of the tenancy. Now, my lords, the petition was originally filed asserting grounds, my lords, under section 27(2) A, B, C, and R. A, B, C, and R, my lords.
Yes.
Then, my lords, with the demise of the original lessor, another prayer was added under section 31A.
Yes.
Which entitles, my lords, a widow to continue the proceeding. Now, my lords, the Honorable Court of First Instance proceeded to allow the petition, although, my lords, it was allowed only under section 27(2)(r), whereby, my lords, the Honorable Court was pleased to note that the landlords required this premises for their own legitimate use. That was a finding, my lords, rendered by the Honorable Lower Appellate Court. I'm sorry, my lords, the Court of First Instance. Now, my lords, the Revision Court has reversed this finding, my lords, on two grounds. Essentially, it is two grounds. One, my lords, the Honorable Revision Court holds that with the demise of the original petitioner, the cause under section 27(2)(r) dies with him.
Yes.
That, my lord, should find at page 26. The observations are at page 26, my lords. Internal page 13 of the Revision Court judgment.
Page 26.
Please, in page 26, my lords, internal page 13.
Yes.
My lords, the bottom paragraph, of course, there is a ruling that has been relied upon, which I would respectfully submit is inapplicable to the present facts. Then, my lords, the Honorable Court proceeds to hold. Therefore, in view of the ratio laid down in the above said decision, the requirement pleaded by the landlord must not only exist on the date of action, but also subsist till the final decree or order for eviction is made. This revision court has to take into consideration the subsequent event, that is, the death of respondent number 1, Mohini B. Rao, for whose bona fide requirement, Mohini B. Rao, my lords, by the way, is the wife of the landlord, whose bona fide requirement the petition A and B scheduled premises sought. As respondent Mohini Rao died during pendency of this revision petition, the ground of bona fide requirement of the petition A and B scheduled premises for the use of respondent number 1, Mohini B. Rao, for her business extinguishes. Therefore, essentially, my lords, the Honorable Court proceeds to hold that the original landlord is dead, his wife also is no more, and as such, the cause does not survive. Now, the question my lords would have to consider, my lords, is whether the cause was confined only to the husband and wife, or would it inure to the benefit of their children as well? My lords, may I take my lords, draw my lords' kind attention to the provision itself for a moment,
Yes.
my lords. 27(2)(r), my lords.
Rent Act idea, Miley.
My lords has it.
Court office. 27(2)(r ni yavada page tagadu kodtira ನೀವು? 27(2)(r) is in page number 69. You have given me somewhere here. 27(2)(r) ಅಂದ್ರೆ correct ಆಗಿ 27(2)(r) ಕೊಡ್ಬೇಕಲ್ಲ? Yes, sir.
Lords, the provision reads thus, my lords, that the premises let are required whether in the same form or after reconstruction or rebuilding by the landlord for occupation for himself or for any member of his family if he is the owner thereof, or for any person for whose benefit the premises are held and that the landlord or such person has no other reasonably suitable accommodation. My lords, this is what the law provides.
Yes.
My lords, here is a case, my lords, where the landlord...
Whether in your petition,
please,
your claim was made exclusively only for the that petitioner Mohini Rao or even for the family?
My lords, it is for the family as well, my lords. In fact, I would draw my lords kindly.
But what you read in internal page 14 is the finding of the trial court that Mohini Rao for her business extinguishes.
Please.
Whether she had sought it for her own business.
My lords, in this context, may I draw my lords kind attention to page 43, my lords. In page 43. Which is, my lords,
Yes.
internal page 7 of the judgment of the first.
Yes, yes.
My lords, has it not? Three lines on the bottom. Wife of the first petitioner.
No.
Wife of the first petitioner. My lords, I'll stop here. When I say wife of the first petitioner, my lords, the cause title clearly indicates, my lords, that their children were also party to this proceeding.
Yes.
Now, my lords, the wife of the first petitioner has been running a business in the name and style of so and so, and the space in so and so in which the first petitioner's wife is presently carrying on her business is not sufficient for her business, and it will also not have the advantage of a road in front.
Yes.
The petitioner's wife also so and so for the purpose of the said business, the petitioner reasonably and bona fide requires petition A and B scheduled premises. My lords, my respectful submission, my lords, is that with the demise, my lords, of the husband and wife, this business was taken over, the existing business was taken over by their own children, my lords, the eldest son, and my lords, even the idea of, my lords, of expansion of the business was taken over by the children, who already were, my lords, parties to the proceeding, original proceeding.
Yes.
As such, my lords, my respectful submission is, upon demise of the landlord and the landlady, the interest, my lords, and the cause under section 27(2) are survives for the benefit of the children, my lords, because business is being continued by the children. My lords, that is my first submission.
Yes.
Now, my lords, coming to the second ground, my lords, on which the judgment has been reversed.
Yes.
My lords, the second ground, my lords, is that of the two premises, the Schedule A premises was measuring beyond 14 square meters, and therefore, my lords, the provision of the Rent Act is not applicable, is what the Honorable Revision Court holds.
Sir, you are not audible.
Am I audible now, Lords?
Intermittently, you went off. You started with Schedule A. Whether it is residential,
I'm sorry,
non-residential.
Yes, my lords, both are commercial properties. Admittedly, my lords, Schedule B property is within 14 square meters. The dispute, my lords, was only with respect to Schedule A premises, where, my lords, it was argued that it is beyond 14 square meters. And as such, my lords, the provisions of the Rent Act is not applicable. Now, those findings, my lord, should find at page 27, my lords, internal page 14 of the Revision Court judgment. Page 27. My lords, point number 2, para 13. Now,
yes,
my lords, this finding is based on a commissioner's report, which, my lords would find the extract at page 29, my lords, internal page 16, the very next page. 3 lines from the top. The said upstairs of the petition A scheduled premises. My lords, has it?
Yes.
The said upstairs of the petition A scheduled premises has been mentioned as a loft in the said sketch. The court commissioner, who has been examined as CW1, has stated in examining in chief that petition A scheduled premises bearing roll number so and so is having a loft or upstairs, and it has been used for storing medicines. And in the ground floor, the business of the medical shop has been carried out. My lords, I'll stop here. My lords, the commissioner refers to a loft, which, my lords, I would say is something like a mezzanine floor, which is, suppose, my lords, if the ceiling height is 15 feet.
Yes.
What the traders do, my lords, is that they build a small upparigan field on atta.
Yes, I have understood. Proceed.
Now, my respectful submission, my lords, is that the term plinth area cannot include the loft area. My lords, if the loft area is removed, my lords, I am well within 14 square meters.
All right.
So therefore, my lords, I have taken a specific contention, my lords, that the engineering standards, my lords, globally accepted engineering parameters says that the plinth area will be only that floor area within those 4 walls.
Whether when you
Not-
gave the
not with-
petition premises to the tenant, this loft already existed or he created it?
My lords, this is something which has not been gone into by either of the honorable courts. In fact,
No,
it
you
is
have
not
you have
gone
to
not-
make a statement.
Please, my lords, I should submit that, my lords, this was not even taken up as a contention.
No, sir.
Please.
What is the fact according to you when you gave this premises to the respondent tenant?
Please.
Is it a registered agreement or an unregistered?
It was an unregistered agreement, my lords, and there is no mention.
There is
of
a
the-
written contract.
Yeah, it's a written contract.
All right. So in that, whether do you say what have you mentioned anything about it?
No, there is no mention of the loft at all, my lords. So I am instructed to submit, my lords, that it was subsequently built by the tenant himself.
All right.
Pausing for a moment more, as there is no ground argued to changing the nature of land lots or alteration, but it was presumed that not it was existing at the time of letting out.
All right. That we will deal with it.
My lords, I'll rest my submissions, my lords. These are the only 2 grounds on which, my lords, the original judgment has been reversed. And my only submission, my lords, is that apart from the misunderstanding, my lords, of the technicalities.
So your first ground, Mr. Ajit Shetty, is that 27-2R would not survive in view of the death of that lady,
No,
wife
I'm
of the original petitioner, because her business would extinguish. This is what the finding given by the revision court.
Please.
And the second contention is
No.
that the loft upstairs is not a part, it exceeds the plinth area.
But may I just clarify my submission? My first submission is that 27-2R would survive because the business has been continued by children. So notwithstanding the demise of the original landlord and the landlady.
Correct.
That would endure, not?
Yes, second submission.
Is that loft cannot be included in the definition of plinth area.
There is a finding that it is included in by the revision court.
My lords, page 27, my lords. Then, my lords, it continues. To page 30. My lords, may I just take my lords directly to page 30. 4 lines from the top. Therefore, the measurement of the said loft. I'm sorry.
Yes.
I'm sorry.
Cannot be included in the plinth area.
The honorable court is I'm not recording my submission. Then, my lords, yeah. I'm sorry, page 19, my lord, page 32, internal page 19.
No, you come to page 31. Therefore, in view of the ratio laid down.
Please. Therefore, in view of the ratio laid down in the above said decision, the frontage of the shop, which measures so and so square feet, has to be taken into consideration for calculating the plinth area of the petition A schedule premises. The measurement of the shop is so and so 141 square feet, and measurement of the frontage of the shop is 22.5 square feet. Therefore, the plinth area of the petition A schedule premises is 163.5 square feet. Therefore, the plinth area of the petition A schedule premises is more than 14 square meters. Therefore, as the plinth area of the petition A schedule premises is more than 14 square meters, the provisions of the Karnataka Rent Act are not applicable, as the petition is carrying on business in the petition A schedule premises. Therefore, as per provisions contained in section 23G of the Karnataka Rent Act 1999, the premises used for non-residential purposes having plinth area exceeding 14 square meters used for commercial purpose are excluded from the purview of the Karnataka Rent Act.
Yes.
But even assuming that this were to be true, this would definitely not apply, my lords, at least to Schedule B premises. Schedule B premises was admittedly, my lords, it is below 14 square meters.
Yes.
My lords, this is all that I have to submit.
So in your petition, you have made A and B schedule, is it?
Please, there are 2 schedules, my lords, 2 separate shop premises. One has a municipal number of 158A and the other is 158B.
And where is the ambiguity here, sir? Mr. Shetty, you yourself make in this petition A and B schedule.
Please.
That means it is two different shop premises.
Absolutely, Manoj. That is what I'm saying. As a landlord, Manoj, that is my specific case, that there are two separate tenements.
No, all right. If that is the case, then it exceeds 14 square meters. So at the most, you would be entitled for eviction of the B schedule property, right?
Please, at least the schedule B premises.
Yes.
Please.
Now, is there a separate entrance for schedule A?
Absolutely, Manoj. These are two, Manoj, these are two small shops in the same building with two separate entrances and frontage. Absolutely distinct, Manoj.
All right. Yes. So your argument now would be that though the trial court has granted the decree in favor of you on both, the revisional court setting it aside should have at least considered your petition for schedule B, which would come within 14 square meters.
Absolutely.
Correct?
Please, absolutely.
Yes, sir. Prasanna, that's all.
So, Manoj, I'll submit my rejoinder, Manoj, subject to what my learned.
Yes, Prasanna.
But though there is no distinct and separate dispute with respect to the factual aspect, initially, the tenants were inducted not by the petitioner who filed the petition before the trial court, but one by Raghavendra Rao, who was the person, a landlord, executed a lease deed dated 2/9/1974.
Is there a rental agreement?
Rental agreement,
Registered?
Unregistered.
Who's this Raghavendra Rao?
Who is his nephew, who filed a HRC petition subsequently.
Huh?
Sister's brother.
Which sister, sir?
Bhaskar Rao is the nephew of Raghavendra Rao. Raghavendra Rao was the original owner. Who executed the rent agreement, rent bond, dated 2/9/1974, letting out the premises bearing number 10-1-158A.
So Raghavendra Rao is Bhaskar Rao is a nephew of Raghavendra Rao.
Yes, yes.
And owner of the property.
Yes,
So Raghavendra Rao is the landlord. The agreement is between you and Raghavendra Rao.
Yes, yes.
All right.
Subsequently,
yes.
Another premises was also let out by the very same Raghavendra Rao in favor of the predecessor of these respondents. The subsequently, since Raghavendra Rao died, the Bhaskar Rao, who was the nephew, claimed ownership by virtue of a will, and subsequently he got terminated the tenancy by issuing a notice, and which was replied by the respondent.
What was your reply?
Yes, reply was issued.
What was your reply, Prasanna?
Please note.
What was your reply, sir?
My reply was that there was no bona fide requirement, and
no, but are you admitting the fact that ownership you are not disputing?
Ownership was not in dispute.
Tenancy not disputed.
Not disputed. In the reply, I have contended that Bhaskar Rao, though acquired ownership, has no necessity to file such a petition. There was
Mr.
no
Prasanna, before proceeding further to hear your argument, without cutting you further, now that you are not disputing ownership and tenancy, it is only on the bona fide requirement which you are disputing, which the revision court has granted in your favor, and the other aspect of the loft of Schedule A property.
Yes,
are you willing to sit for an amicable settlement with the landlord?
I will convey the same word to my party, and I will come back to the honorable court with the instructions.
Yes, Mr. Ajit Shetty.
Very well, Manoj, of course. Manoj,
this petition is 1996
Absolutely, my lords.
The agreement is entered in the year 1974.
Yes, Lord. Yes.
ಯಾವಾಗಿಂದ ಇದ್ದೀರಾ ಮಿಸ್ಟರ್ ಪ್ರಸನ್ನ ನೀವು ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ?
Lord, when the requirement, Lord,
If I am not mistaken, Mr. Prasanna, I think you settled one matter before me. I think some very old matter.
Yes, Lord. Yes.
Yes, you can make an effort even in this.
Definitely, Lord. I will convey the same, Lord, to the Lord, to the parties, and Lord, I will come back to the honorable.
It is a small shop. I think you are running some medical shop.
Yes, yes.
You have used it enough. What is the rent now you are paying?
Rent ಕಟ್ಟೆ ಇಲ್ಲ.
ಅಲ್ಲ, ಅವರು ಹೇಳ್ತಾರೆ ನನಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಬೇಕಾಗುತ್ತೆ. I am not agreement with my learned friend. Renting ಬಗ್ಗೆ I cannot.
All right, doesn't matter. Now you find out from your client what is that, whether when he can vacate, and inform Mr. Ajit Shetty.
Please.
And then you can get back. We'll have it next week.
Please, no.
Or you want more time?
10 days not enough, Lord.
All right. 10 days is okay, Mr. Ajit Shetty.
Absolutely, my lord.
Barkali, heard. Learned Counsel Sri Ajit A. Shetty for the in WPA, neither.
Expedition. My another point of argument is that maintenance of the expedition also, Lord.
I thought it was an HRRP. What is this WP?
My lord, it's a writ petition, my lord.
No. For what are you challenging here?
The order passed by the revision court. HRC, my lord, it's a HRC petition.
You're supposed to file HRRP or what?
Yes, my lord.
Huh?
My lords, as against a revision petition, my lords, there cannot be a second revision. Therefore,
so this is all right. You are challenging the orders of the revision court.
Please, it's an order of the revision court.
But 115 Lord is available as par with the previous act, Lord. Therefore, it may not be maintainable. However, Lord, since Lord, the honorable court suggested to resolve the dispute.
I think you have to examine this aspect also, Mr. Ajit Shetty.
Very well, my lords, very well. I'll do that. But the settled law, my lords, is that there cannot be two revisions.
No, they. All right. You find out. Examine and enlighten me also on this.
Very well.
All. Third Learned Counsel Ajit Shetty for the petitioner, landlord, and Sri Prasanna VR for respondents 1 to 3 on behalf of the tenant. Respondent tenant. Full stop. Both learned counsels submit that they will explore the possibility of an amicable settlement for which 10 days time would be required. Acceding to the request, release this matter. 10 days admin on. Release this matter after 10 days.
Apply.
Prabhudeva. What is this matter, madam?
Responding to Lord issued the forfeiting order on 14/5/2020, that has been stayed by this honorable court on 18/8/2021. I filed the IA for direction, my lord. After staying the order, my lord, they are not issuing, they are not allowing me to do the business in shop number 190, my lord. And
what have you filed? You filed an IA?
IA for direction, my lord. Filed on 18/1/2022, my lord.
Your Lordship, I am appearing for the respondent number 3.
Yes.
Your Lordship, my senior is not keeping well. Kindly grant a short accommodation. He is suffering from cold and fever.
For what?
Since, my lord, there is a stay from this honorable court, they are not allowing me to do the business, my lord.
Where is your
18/8/2021 stay has been done.
18/8/2021,
my lord.
Your Lordship, we have filed the objections regarding this.
You're challenging annexure G. What is annexure G? Page. Page number? Yes. Where are you reading? Page. No, you come to the operative portion. What is that? You can tell the sum and substance. What is that order?
Order minus that I have not paid the, due to COVID situation, my lord, I have not paid the amount of 658,000, my lord. Even license fees, my lord, 658,000.
So you have now paid that?
I have paid that, my lord. After that, they have issued the stay the operation portion, my lord.
When is the order? This order is dated?
26/2/2021, annexure G, my lord.
26/2/21. So after that, the interim order is passed. You have submitted that you have paid that amount. All right.
Yeah, they've paid that amount at a later stage. Which is not.
Paid the license fees.
All right. What are you running there? What are you running? What are you running there? What shop are you running, madam?
Shop, my lord, that is I'm doing I'm a commission agent, my lord.
Ah.
Commission agent, I have a shop come go down, my lord. Shop number is 190, my lord.
All right. All right.
Some 2020, my lord, I have not paid some of the amount to the one farmer, my lord.
Now, who's this contesting respondent number 3?
So we are from APMC Yashwantpur.
APMC Yashwantpur. Before it is a Yashwantpur APMC, my lord, that has been shifted to Dasanpura, my lord. It is the new.
Now the shop is allotted to you by R3. So there is no rival claimant. No rival claimant.
They have allotted it. Now they have forfeited my order, my lord. Forfeited order has been passed.
When?
14/5/2020, my lord. That has been challenged before appeal, my lord. Appeal order is, my lord, page number 34, saying that to pay the amount.
Page number?
34, my lord.
Page number 34 is the same, annexure G.
Annexure G order has been passed by the appeal, my lord. That the 14/5/2020 order has dismissed my appeal, my lord. Then I have come to this before this honorable court. This honorable court has stayed that order.
Your lordship, they have not challenged our orders, both of the orders.
Annexure G is the 14/5/2020, my lord. That is the forfeit order has been passed. That has been filed appeal, my lord.
Annexure G is forfeiture order.
Annexure E is the forfeiture order, my lord. Page number 26.
Page number?
26, my lord. Ishwar traders number 190, Shaya.
So this is on 14/5/20. One minute, madam. 1 minute. 14/5/20 is annexure.
Annexure E.
Annexure E. What does annexure E say? Forfeiture.
Forfeiture order.
And what is annexure G you said?
I have filed the appeal, my lord.
What happened in appeal?
Appeal, my lord, they have dismissed my appeal case, my lord.
What are we challenging here?
The same order has been challenged.
Which order?
26/2021, my lord.
26/2.
26/2, my lord.
That is your dismissal, madam. You have to challenge annexure E.
Annexure is challenged before the appeal, my lord.
What happened? What happened there?
Page number 34, they are saying that ಪ್ರತಿವಾದಿ ಸಮಿತಿಯು ಕಲ್ಲಾಗಿ ಲೈಸೆನ್ಸ್ ಅನ್ನು ರದ್ದುಪಡಿಸಿರುವುದು ಮತ್ತು ಮಾನ್ಯ ಸ್ಥಳೀಯ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಕಾನೂನು ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಮುಕ್ತವರಿದ್ದಾರೆ ಅಭಿಪ್ರಾಯಿಸಿ ಡಿ1 ಲೈಸೆನ್ಸ್ ಪತ್ರದ ಆಧಾರದ ಮೇಲೆ ದಾಸನಪುರ ಉಪಮಾರುಕಟ್ಟೆ ಪ್ರಕರಣದ ಡಿ1 ಏಕೆ ಸಂಖ್ಯೆ 190ಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸಮಿತಿಯೊಂದಿಗೆ ಮಾಡಿಕೊಂಡಿದ್ದ ಡಿ1 ಲೈಸೆನ್ಸ್ ಕರಾರು ಪತ್ರದ ನಿಬಂಧನೆಗಳು ಉಲ್ಲಂಘನೆ ಮಾಡಿರುವುದನ್ನು ಸ್ಪಷ್ಟವಾಗಿರುವುದರಿಂದ ಸಮಿತಿಯು ಸದರಿ ಅಂಗಡಿ ನಮ್ಮ ಗೋಡೌನ್ ಸಂಖ್ಯೆ 190 ವಶಕ್ಕೆ ಪಡೆಯಲು ಹಾಗೂ ಹಂಚಿಕೆ ಸಮಯದಲ್ಲಿ ಪಾವತಿಸಿದ ಇಎಂಡಿ ಮೊತ್ತವನ್ನು ಮುಟ್ಟುಗೋಲು ಹಾಕಿಕೊಂಡಿರುವ ಕ್ರಮವು ಕಾನೂನುಬದ್ಧ ಕ್ರಮವಾಗಿರುತ್ತದೆ ಎಂದು ಘೋಷಿಸಲಾಗಿ ಈಶ್ವರ್ ಟ್ರೇಡರ್ಸ್ ಸಲ್ಲಿಸಿರುವ ಮೇಲ್ಮನವಿಯನ್ನು ವಜಾಗೊಳಿಸಿದೆ. That has been challenged in this petition. Have paid the
All right, now you are running the shop.
No, my lord, after that stay also, they have not issued the possession also, my lord.
Yes, why? Respondent number 3.
Sir, they are not in, your lordship, they are not entitled for possession because they didn't pay the farmers' dues on time. And plus addition.
Madam, your annexure G has been stayed by this court.
Sir,
By
additional.
order dated 18/8.
Sir, sir, just a minute. Let me refer to Annex G. I'm sorry. Your lordship, I'm not able to understand Kannada. My senior is not well, but as far as I know, they had to pay additionally 1% also of the.
You paid the entire amount?
I have paid the entire amount and also farmer dues also I have paid, my lord. After that only I have produced all the documents here before this lordship.
Now they are not permitting you possession. So you are not running the shop now. Madam, when will you tell? When is your senior coming?
Sir, just grant a short accommodation. Within 1 week, he'll be here.
Day after tomorrow. Then I'm a date of 15. All right. Learned counsel for the petitioner is present before the court physically. What is your name, madam? Shilpa Rani. You have wakalat? No, you have wakalat or you don't have wakalat in the name? Oh, Shilpa Rani. Srimati Shilpa Rani on behalf of Shri Prabhudeva for the petitioner is present before the court physically. To stop learned counsel for respondent number 3 submits that the counsel on record is not keeping well and seeks for adjournment. Learned HCGP for the state for respondent number 1 and 2 is present physically. Full stop. Acceding to the request of the learned counsel for respondent number 3, read is this matter on 17th.
Much obliged.
Tell your senior madam to come on 17th.
Yes.
And if they have paid the entire amount, you have to give them possession. You can't accept they take the money and not give possession to the.
Sir, I'm sure there are some facts which are not.
Find out, madam. You cannot come and give if and but situations and not be sure about your own facts.
I'm sorry.
Lokesh. Harish Bandari.
Yes, I have.
MV matter, motor vehicles.
Please, brother.
KSRTC, na? APRTC. KSRTC. What is this? Just to be heard.
What has happened in this? Before that, my one submission. Tribunal has passed a common order. 4 permits were involved. I filed first writ petition. It was several occasions it came or interim order was not granted. And there's objections for 5 on 18/1/2022. Against the same common order, this honorable court has passed the order. Section K is the common order passed by the tribunal. That is 24/9/2021.
There's 2 issues now. Whether the right to submit conducted authority is influence or whether the this issue should have now I will not take much to this issue, sir. The loss of the candidate to bear on
because I have stopped the vehicle. Stopped the vehicle from 24/9/2021. Because there was no stay order by the tribunal. KSRTC filed revision petition, there was no stay order. And this honorable court has granted.
No, whether you are running now, your stage carriage. This stage carriage.
Stage carriage.
You're running.
after the order of the tribunal, I have stopped.
Hmm.
Now I am, a vehicle is idle.
Hmm.
I paid insurance tax, everything.
Ah.
Let the date may be fixed, any date, tomorrow or day after tomorrow. I may be permitted after. Because this is 200 kilometers. Their allegation is 1.1 kilometer overlapping. And that too,
all right,
notification.
This court will hear you. This court will hear you. Yes. No, in the connected writ petition, there is a stay granted. That is what he is now bringing. So let that also follow, and we'll hear you even in the, along with all other petitions. Yavrali, other lucky dira, no doubt. But the fact remains that there is a stay granted by this court. So that will ensure to his benefit till at least let him operate till then, till we vacate the stay or continue. You don't precipitate, let him operate. There can't be now two divergent orders by this court. Is it similar, common order?
Same order.
No doubt you have appeared here. In that case, you may not have appeared. But
he has taken notice, my lord.
In this case, I appear.
Yes. Yes.
Because in the complaints of the officer. So, obviously, it was like that for the reason that for the complaints of the officers.
Here also it is overlapping. Case of overlapping. That has to be considered. Correct, but that has to be considered by this court. That has to be considered. So till then he has to be permitted to operate. Huh? To argue the matter on. All right, then we'll hear you. We'll hear you. Both of you will hear. Afternoon. Huh? No, now the time is up. I have to hear you. I don't know the facts of this case. So we'll have it after tomorrow. We'll hear you. Till then, you permit him.
I stopped because they are not operating.
You want to file your statement in this or something? You already filed. You want to file anything? You filed.
Everything is complete in this case, my lord.
All right.
The only reason they are not operating entire route, my lord, only 1.1 kilometer out of 200 kilometers.
Heard Learned Counsel Lokesh R for the writ petitioner and Learned Counsel Sri Harish Bandari for respondent number 2 and Learned HCGP for R1. Full stop. Due to want of time, this matter is adjourned to 17th. 17th. We'll hear it. 17th and pass out.
Yes. Only for this reason, seeking for stay, my lord, because they are not.
18th.
Till then, but one thing is already stay granted by this court.
You'll be also benefiting that. So I already expressed if you take.
Definitely, I agree with you.
See, there cannot be two. One for the goose, one for the gander.
And that matter can also be.
We'll see if that comes earlier.
Also, so that he says that he has vacating.
When is it?
It is date is not given.
What is the WP number?
I have mentioned.
Really, what is it? We'll say that it.
265 of 2021.
21.
265 of 2021.
No date is given in that.
No date is given.
All right, let this come. We'll see, because this is I have not heard this matter on facts of this case. Let it come up on that day, 18th. Then we will 18th, 17th. My board is full. Board is full. It may not reach again. This is the same thing will happen. I want to give some time and understand your case. Sorry. ಹೌದು.
One thing is
They are not operating these services. Your Lordship may kindly see the SPU rules. They have not filed application. But they say, court has said, without permit we can operate. Let them show.
Bring it to the notice. Bring it to the notice. Yes, Mr. Prashant Chandra. Yes.
Third is my matter where I am the petitioner. Court fee valuation ಬಗ್ಗೆ 5 ಲಕ್ಷ ಒಳಗಿದ್ರೆ that court has jurisdiction. Beyond 5 lakhs, that court has not jurisdiction. Another ಪ್ರಕಾರ it is beyond that jurisdiction of 5 lakhs.
So you are the defendant. All right. So what has the trial court done?
Trial court ಹೇಳಿದ್ರೆ it is less than 5 lakhs, therefore I have jurisdiction.
Who is the respondent?
ಏನಾಗಿದೆ, kindly go to the order of this court on 15/11/2000.
15/11.
So and so, the learned counsel for the petitioner has pointed out that trial court has proceeded to determine the value of 375, considering only one item of and ignoring other items. If both the suit settled properties are considered to go beyond 6 lakhs, and principal civil judge JMF model will not have jurisdiction.
Yes.
Said submission placed on record, issue emergent notice to the respondent, stay as prayed for is granted till next date of hearing.
So you have a stay now.
I had this stay, not continued, and the court was proceeding. That's why I asked for a continuation in order.
So you have filed an extension. When it was not extended?
It was there up to only from the 15/11/2017. Thereafter, it has not been extended.
Why?
The matter had not come here. Then it came for admission. At the time, I forgot to ask for extension.
So from 2017, the next it came to 2019.
I mean, 8/12/2010.
So that application, your objection hakidare na? But what is the trial court now doing? Proceeding with the matter. What is the stage? So you are the defendant. You have cross-examined PW1?
Yes.
You are cross-examined.
Jurisdiction boroದ್ರಿಂದ we have to take this seriously. Otherwise, we are finally we are subject to this scheme about.
Our illa na ilwa Allah counsel. Where is Mr. Ramesh and G. Uday Kumar? IA for extension of stay filed by advocate is returned. Office objections.
Copies of my
Then you have to serve the copy.
not been able to get in because this
Trial court ಅಲ್ಲಿ ಇರ್ತಾರಲ್ಲ. I'll direct you to serve to the learned counsel there. Heard learned counsel Sri Prashant Chandra, yes. Send for the petitioner defendant, who has filed an application for extension of stay granted by this court on 15/11/2017. The registry has raised objection with regard to non-service of copy of the said application to the counsel for the respondent. Full stop. Learned counsel for the petitioner is permitted to serve a copy of the said application IA number 1 of 2022 to the learned counsel appearing for the respondent plaintiff before the trial court, and thereafter move this matter. Inform Madi, the matter is being heard in the trial court in New York. Yes, madam. Yes. 21, you have interim order. Interim order shall stand extended till next date of hearing. Who took time? Respondent took time, is it? They have not informed you. So specifically made clear to him that he has to inform you. Make a mention on the next date of hearing. Interim order granted earlier shall stand extended. Granted earlier, if any, shall stand extended. This is the matter with Prasanna and Ajit Shetty. Huh? Correct. Yes, Mr. Prasant Chandra, you're appearing after a long time. You're still in the mediation as a senior mediator? Good. So you don't want to enlighten me by this. All right.